May I please Lordship? I beg to mention item number 21. The respondent has filed an affidavit of opposition. 2 weeks time may be granted for filing reply.
21.
21. And for the petitioner.
As paid for by the counsel for the petitioner. 2 weeks time is granted for filing rejoinder affidavit.
Obliged.
The affidavit in opposition filed by the respondents.
And with consent of the other side, Milord, I beg to mention item 26, Milord. Well, in this case, I'm appearing for accountant general, Milord. It's required to file an affidavit, Milord. So next 20, Milord, next Friday, Milord, will come, Milord. I've taken consent of the other side. Already taken. Next Friday, Milord.
Mr. S.K. Mehdi, learned counsel appearing for the AG Assam, submits that he may be given a week's time to file counter affidavit.
Yes, Milord. Counter affidavit.
Counter affidavit. And also submits that he has taken the consent of the other side.
He's here, Milord.
In view of above, and has straightforward is the matter again on
20, Milord.
20 September 2024.
Milord, other matter, Milord, item number 42, Milord. Well, my friend is appearing for a repetition, Milord. It's 2015, Milord. I've received the record, Milord, but it is in vernacular, Milord. Some Bengali and some Hindi, Milord, regarding the record, Milord. A dismissal matter, Milord. So may I pray this matter after 2 weeks, Milord? In the meantime, Milord, the required, Milord, is some relief and person may be translated, Milord.
If it comes before the appropriate bench, maybe
Yeah.
translation may not be required also.
Yes, Milord.
The problem is this court cannot read.
Yes, Milord. This is one Bengali and some Hindi person, Milord.
Mr. S.K. Mehdi, learned counsel appearing for the respondent, Union of India, submits that he has received the records, but some of the documents are in vernacular. And therefore, translation will be required. Mr. As paid for, matter stands adjourned for 2 weeks.
Yes, Milord.
The learned CGC shall do the required translations in the meantime.
Milord, yes, Milord.
May please, Lord. I will to mention item number 15, madam. This matter become infractious matter. It's
15.
Item number 15, madam.
1-5.
1-5.
You're for the
I am for the petitioner.
good name, please.
K. Burua.
Mr. K. Borwa, learned counsel for the petitioner, submits that the writ petitioner has become infructuous. In view of above, the writ petition stands dismissed as infructuous.
May I
Obliged.
please your Lordship, with the consent of the petitioner, I beg to mention item number 28. Lordship, I am
28.
Lordship, I need 2 weeks time to file our objection. I am appearing for 8 and 9, Lordship.
Objection means
Affidavit in opposition, Lordship, on behalf of 8 and 9.
counsel for the respondent number 8 and 9 seeks 2 weeks time to file counter affidavit. Who's for the petitioner?
Number 5 also. I'm appearing for respondent number 5 also.
So, what is your submission?
I have no objection to the prayer.
So, what about the petitioner?
They have no objection, Lordship. I have
If-
taken consent, Lordship.
What? Please read what I've said. Stop. The same is not objected to by the other side. In view of above, matter stands adjourned for 2 weeks. Let counter affidavit be filed in the meantime. Yes.
May please, your Lordship. Lordship, I beg to mention item number 43, last item of the daily list, Lordship, hearing matter. Lordship, with the consent of the other side, Lordship, matter may come up after 2 weeks, Lordship. Some developments are there in the case, Lordship. The matter is to area salary. Some of the part of the area salary has been paid. So I
You are for the
petitioner, Lordship. I have taken the consent from the respondent authorities, Lordship.
learned counsel for the petitioner submits that he needs to take further instructions from his client, and therefore the matter may be adjourned for 2 weeks. Prayer is not opposed to by the learned counsel for the opposite party. Stop. In view of above, matter stands adjourned for 2 weeks.
Deeply obliged.
Lordship, I have filed an application for restoration of the writ petition. Lordship, you remember the matter, day before yesterday, it was dismissed.
Hmm.
Accordingly, I mentioned, and
Hmm.
the director has directed to file a application. So I have filed, Lordship. It may come up on 17,
When did you file?
today.
You have filed today.
Yes, Lordship,
Okay.
17, no lies.
May it please your lordship. Lordship, may kindly allow me to withdraw item number 29. Matter has become infructuous.
Your good name?
Lordship, H. R. Das.
Mr. H.R. Das, learned counsel for the petitioner, submits that the matter has become infructuous.
So I am appearing Bank of Baroda, Lordship. My name is recording.
Stop.
Response
Miss-
number 1 to 4.
Miss
BP
your-
Bora. BP Bora.
BP Bora, learned counsel appears for respondent number 1 to 4 and agrees to the submission. Next para, in view of above, the writ petition stands dismissed as infructuous.
But this is a matter of 2013, my lord, it was listed yesterday, but due to paucity of time, it could not be taken up. by
Which one?
lordship.
Which matter?
This, the petitioner, I'm paying for listing this matter, my lord. It
Oh,
was
you're
listed
paying for
before your lordship.
listing.
Yes, my lord. It was listed before your lordship yesterday.
Ah.
Due to paucity of time, it could not be taken up. My lord.
When do you want it?
Can it be listed in the next week, my lord? Either Tuesday or Thursday, my lord. 2013 matter, my lord.
There's a lot of matters listed next week.
2013 matter, my lord. That is why, my lord, I'm saying.
Huh? When do you want it? Friday?
My lord, Tuesday or Thursday, my lord.
You want a hearing date?
My lord.
It is for hearing
Yes, my
or
lord, for hearing, my lord.
admission hearing?
No, my lord, regular hearing, my lord.
Okay. First day,
My lord.
12th. I'm sorry, 19th, not 12th, 19th.
Of this.
May please your lordship, because I am appearing for respondent number 4. I need 1 week time to file affidavit, my lord. Affidavit is ready.
Since 2020, he is deprived of the consequence benefit of service. And
A
pursuant
date may be fixed, my lord, any,
Yes.
a date may be fixed, my lord.
What is the item?
31,
31.
pursuant to last order, they have appeared. The main incumbent respondent number 6 is already.
Respondent number 2,
4, my lord.
respondent number 4. You are Mr. Datta?
S. Kotoki.
S. Kotaki.
Yeah.
Learned counsel, Mr. S. Kotaki, appearing for respondent number 4, submits that he may be given a week's time to file
Affidavit.
affidavit. To file Shogo's reply
Hmm.
in the form of an affidavit. The counsel for the petitioner submits that it's a long pending matter, but agrees that affidavit is required to be filed. In view of above, a week's time is granted as prayed for.
My lord.
List again on
20.
When?
20th of September, lordship.
25th,
20, lordship.
on 20th of September, 2024.
Master lord.
Obliged, lordship.
Yes. Office not dated. No, before that you write like this. None appears for the petitioner when the matter is called. Stop. Office note dated 11/9/2024 indicates that neither AD card nor unserved notice has returned back from respondent number 2. In response to the notice issued on 10/8/2022. Since the petitioner is absent today, no, since the petitioner is not represented today, let the matter be listed again after 2 weeks. Yes, what is this matter?
Lordship, this is about family pension to the petitioner, Lordship.
You have filed your affidavit.
Affidavit has not been filed, Lordship, but our instructions are here, which says that the eldest widow will receive the family pension, even if there is an agreement between the two widows. The eldest,
There are 2 widows.
yes, Lord.
Who's the pensioner? Their husband.
Husband is deceased.
Anyone for respondent number 6? No one. Although the Learned State Council is present, neither the petitioner's counsel nor the respondent number 6 counsel are present. For ends of justice, matter stands adjourned for 2 weeks. None appears for the applicant when the matter is called. For ends of justice, matter stands adjourned for 2 weeks.
In this case, one issue that has happened is that, Your Lordship, even from 2019, the copies does not appear to have been served on us, respondent number 3. So with that observation, Your Lordship, may perhaps be pleased to adjourn.
Respondent number 3.
Yes, the Labor Commissioner, Your Lordship. Both in IA and the IA copy has been served, but the writ petition copy has not been served, Your Lordship.
What is listed today is IA.
IA for substitution. Otherwise, Your Lordship, it can also be simply adjourned because others are not appearing, Your Lordship.
Same order, huh? We'll adjourn it for 2 weeks. Let them appear first.
36.
Okay. My lord, kindly pass over time being, my lord. Fact taken up in next item, my lord.
That's why I need some time also to file an additional affidavit. Because they have recently filed a loss of affidavit reply, and some new document has been brought on record. So I want to reply to that.
What is that new document?
Lordship, they have not annexed the original, but type copy has been annexed. So I am also in Lordship.
Huh?
Not
Which,
sure what
which
is
type
the
copy?
Lordship. Reply to the affidavit in opposition filed by respondent number 4. And they have also annexed some documents. Original is not annexed, Lordship, only type copy probably it is. It was filed on 31st of August 2024.
What is that document you're talking about?
Lordship. So it has been annexed as well as minutes of a meeting, but the original version is not here, Lordship, not annexed.
Where is that?
And date is also not here. Page number, Lordship, running page 117.
My lord, as a petitioner, my lord, your lordship will find in page 102, that in their affidavit, in the vernacular, they have stated that প্রস্তাব গ্রহণ করি সিলিং পানি যোগান জানিয়ে ভূমিধর হিসাবে সরকার বিভাগীয় প্রশিক্ষণ হওয়ার ভাবে আজি সভায় প্রথমে শ্রী লুটুমণি হালিক বাছনি কৰি দিয়া হ'ল. It is their document in vernacular which says that the petitioner was selected for the post. It is their document, my lord, I am insisting on.
No, but this annexure F,
In which, F in what, my lord?
your reply affidavit,
Annexure F, page.
where is the original? 116.
116. 116 is sorry, 117, I think.
117 has been cut. Now it's 116.
117.
Some repagination is there.
It is here 117 also.
117, my lord.
He wants to take instructions on this.
You want to take instruction on?
Yes, yes.
Alright.
How much time?
For 2 weeks close.
Counsel for the respondent, Mr.
J. Kolita.
J. Kolita.
Respond number 6 and 7.
Counsel for respondent number 6 and 7, Mr. J. Kolita submits that he may be granted 2 weeks' time to seek instructions.
Well, in the meantime, government should also file an affidavit to that.
On the reply affidavit filed by the petitioner. Government,
We'll file it.
prayers allowed. Similarly, respondent
1 to 3.
1, 2, and 3 are also given 2 weeks' time to file their counter affidavit.
That's.
May I please, Lordship? In this case, state respondents are supposed to file affidavit.
Item 37.
37. We have challenged the gradation list for promotion lawsuit. Petitioner will be retiring in the year 2026 lawsuit.
You have challenged the
Gradation list.
gradation. You have been downgraded.
Yes, I have been downgraded.
Who are the respondents?
Now,
Official
PNRD
respondent.
department lawsuit. Private respondent did not appear.
The notice is complete.
Yeah, notice complete, service form. Lordship may kindly see order dated last 20th March. 2024.
20th March. How many respondents are there in all?
Total 40,
40.
44. 44, Lordship,
So
others are earlier served. These 4 persons who are left, they were served to the department.
I see.
No, amount of it for delivery. No, I mean instructions for delivery. That was complete to 1 hour.
Oh, complete.
No, last order 362.
Other order, official order as well.
Yes.
Lordship, as for last order, it was the service is not complete as of yet to all the respondents.
No, it is complete.
Dated 23/2024,
Complete.
Dated
23/2024,
28/3.
20 March 2024.
There's no such order. The last order is 19th of March,
Yes, 19th of March.
not
Yeah.
20.
20th of March. Team served, it has been team served.
You're for which party?
PNRD.
So you be concerned about PRD. What is your submission?
Lordship, we still haven't received any instructions.
So
Matter may come up for admission, Lordship.
how
By
many
this time-
months should we wait for your instruction? How many years? How many months?
Sometime maybe even Lordship.
How much time?
After vacation. Lordship.
Vacation. Counsel for the PNRD department, Mr.
AK Ghosh.
AK Ghosh, prays for 4 weeks' time to
It
obtain
may be
instructions.
kindly be fixed, otherwise matter doesn't
To
come.
obtain instructions and to file counter affidavit. No, although no one appears for the private respondents, they are also given 4 weeks' time to file their counter affidavit. Please advised. Here's the matter again.
23rd October.
On 23rd of October.
Much appropriate.
We have otherwise filed the affidavit. you know. They
What
have
is
not
this
filed any
IA for?
reply. They have taken time on many occasions, but till date, they have not filed. We have filed it on 16/3/2022.
Any interim?
There's no.
No one appears for the petitioner when the matter is called, although Mr. D.
Bora,
Bora, learned counsel for
for the government, for the response.
Learned State Council appearing for the state respondents is present. For ends of justice, this is the matter again after 2 weeks. Similar order.
Your Lordship, kindly pass over the matter at 2 as my seniors in life.
What is the matter about?
In this case, Your Lordship.
You don't need your senior. You don't require your senior to move an IA. What is the IA about?
Not in this case, Your Lordship.
You're not in this case. How is that? What is your good name?
As they,
And who's your senior?
Anish Barhuya.
So your senior's name is here.
Yes, Your Lordship.
Your name is S. Day.
Yes, Your.
Heard Miss S. Day, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 1525 days in preferring the connected Miss Case number 61 of 2024, seeking restoration of contempt case C number 184 of 2015. Issue notice returnable by 4 weeks. Applicant to take steps for service of notice by registered post with area due within 4 days. List the matter again after, make it 3 weeks, list it after 3 weeks.
May I please, my lord, I have missed the item number 32 and 33, my lord. My name may be kindly be recorded.
32,
32 and
33.
my lord. I have
How-
on lakhs,
how do
my
we
lord,
record your
number
name?
3.
Huh?
Matters related to part, 33, my lord, matter is relating to pension, my lord. Family pension, my lord.
Where were you when the matter was called?
My lord, I am on lakhs court number 3, my lord.
You
I am
should have,
extending counsel NCT, my lord. That's
Huh?
why- Extending counsel NCT, that's why I am appearing before. My
you
lord,
should have informed somebody. 32, 33, what did we write? We'll change the date. Let the matter be listed again on Monday,
Monday, my lord.
Monday,
Both the matter.
both the matters.
Oblige.
Lordship. Lordship. I apologize, Lordship, in item number 34. In item number 34, Lordship, I apologize. I was in court 7, Lordship. Kindly, my appearance will be recorded,
It
Lordship.
was not dismissed. It'll come back after 2 weeks.
Uh, Lordship, my appearance may kindly be
Huh?
recorded. My appearance may kindly be recorded,
Why?
Lordship. I apologize, Lordship.
What is to be done otherwise? Tell me.
Lordship,
Why is it listed today?
Lordship, they are yet to file their affidavit in opposition, Lordship.
Huh?
They are yet to file their affidavit in opposition, Lordship.
Who?
The respondents, Lordship, in the IA.
See, all we can do is we can list it again next week if you want to, nothing more than that.
Other side was required to file the affidavit.
We'll list it again after, it's coming up after 2 weeks.
Yes, yes.
No adverse order. Yes.
Much obliged.
May I please your lordship? My lord, I is for restoration, my lord.
Any delay?
Delay is also there. 164 days delay.
So notice will go.
Yes, my lord.
Your good name?
P. Talukdar.
Heard Mr. P. Talukdar, learned counsel for the applicant who submits that by filing this application, the applicant seeks condonation of 164 days
My lord.
for referring an application for preferring miss case number 65 of 2024, seeking restoration of WPC number 1295 of 2018. Issue notice returnable by 3 weeks. Petitioner to take steps. Oh, who's the respondent?
Respondent number
State.
8, 9, 10, my lord.
Where's that?
It is respondent number 6, 5, 6, 7. And 8. Private respondent. 1, 2, 3, 4 government.
Yes. Government means which department?
Department, my lord,
How will you serve notice?
file established for 6, 7, 8. 5, 6, 7, 8. And
You have served notice to the government advocate.
my lord,
How many copies?
4.
4. Counsel submits that he has served notice to the respondent numbers 1, 2, 3, and 4 through the government advocate by supplying 4 copies of the application. Stop. As such, notice upon the said respondents is waived. Stop. The petitioner shall take, no, applicant shall take steps for service of notice upon respondent numbers 5, 6,
7, 8.
7, and 8 by registered post
My lord.
with
3
ADU
days.
within 4 days. List the matter again after 3 weeks.
My lord.
Lordship, kindly pass over the matter for timing.
My lord, it was for instruction, my lord, only. The authorities have taken up.
Lordship, I have just received in the WhatsApp. It was forwarded on 2nd of April 2014 to the government by the IS. of
Can you
the-
print it out?
Lordship, I have just given. I'll give a print. Director, secondary.
This is from the inspector of school
Yes,
to the director.
Director of Secondary Education, Government of Samgas.
Director is not the government.
No, it has to be forwarded to the director. Thereafter, Lordship, as per procedure, he will take the consent of the government, Lordship.
That is the usual procedure. You
Yeah.
said it has been forwarded to the government.
Yes, Lordship, that was.
This is only from inspector to the director.
Yes, yes, my lord.
Director will again forward to the government for the approval of the government,
Yes,
isn't it?
yes. This was done on 2nd of April.
This was on 2nd of April.
Yes.
This is not a very latest information.
Yes, my lord, till now, the ISS of BTC, he has not received any communication with regard to any correction or.
You're
any-
for the BTC, isn't
Yes.
it? And this will go to which department?
Director of Secondary Education, Assam, Lordship.
No, that is the director, the government,
Thereafter, it will go to Secretary,
Secretary of
Secondary Education, Lordship.
Secondary Education.
Yeah.
Any counsel for secondary education?
Lordship, no one is here.
Hmm?
Nothing, I don't know.
See, as per this letter, it says post of principal also and post of vice principal also. Two posts.
Two posts, Lordship, for creation of two posts, they have given the proposal.
But this was in April. Yes, you are there for the who? Oh, you are for one of the party.
Yes, yes.
Hmm. Is there any counsel for the secondary education department?
Lordship may in fact peruse an order which was passed in the draft of petition, my lord,
Which order?
dated 12th of September 2022.
Which order?
My lord, that order dated 12/9/2022, passed in the batch of writ petitions, my lord, 3550. Or in fact, IA 1594.
Order dated?
Order dated 12th of September 2022.
IA number?
IA civil number 1594
Oh.
of 2021.
Order dated?
Order dated 12/9/2022.
12/9.
Yes, my lord. It should be in the writ petition also, ma'am. It was tagged with the writ petition as well, my lord. Lordship may also peruse the order passed in the writ petition 3550. Order passed by Honorable Justice Zamir.
What does it say? You just read.
My lord, here it says the standing council submitted that the matter is pending for consideration before the secondary education department regarding creation of post. May I read, my lord? Lordship, I can forward a copy, my lord.
You have a copy of the order of 27/9. My order.
27/9.
Yes. In the IA itself.
Which lordship has modified the order.
Yes.
Yeah, that I have, my lord.
Out there also it is reflected.
Yes, yes, that is also.
It is also reflected in the second last order,
Yes, yes.
second last paragraph.
Yes,
That was in 2022.
yes. Lordship may.
So we'll direct within a time frame. Education is, secondary education is a party here.
Yes. Or lordship, then my lordship may fix after vacation so that up to date instructions may be placed. Otherwise, it will be kept pending like this, my lord, if matter is disposed of. That is why, while modifying the interim order, lordship was not pleased to dispose of the writ petition because the matter may be kept pending if it is closed. That is the reason, my lord. Perhaps lordship has not.
Now, who is the counsel for secondary education department?
SMC history was appearing on the.
Huh?
We have informed them. We have informed the secondary education council.
Are they coming? Or we'll call the secretary to appear. If councils are not appearing, we'll call the department. Okay. We'll post it again after the vacation.
Lordship.
All right.
Yes, Lordship, I will. get
Please
out.
write, parties are represented by the respective councils. In terms of the last court's order dated 12/9/2024, Mr. B. Chaudhary, learned Standing Council BTC has produced a communication dated 2/4/2024, by which the Inspector of Schools, BTC Mushalpur, has submitted a report on creation of post of principal and vice principal in connection with WPC number 378/2017 to the Director of Secondary Education, Assam. Stapler. Next para. Be it stated herein that the entire controversy is in respect of holding the charge of principal of Dakshin Bijini Adarsha Vidyapit Higher Secondary School. Stop. The said school initially was only in high school, but with the upgradation of the same to a high secondary school, the post of headmaster was abolished, and in the absence of a regular principal and also a post of principal, the same has been held on in charge basis, initially by the private respondents concerned, and thereafter by virtue of the order passed by this court on 27/9/2022 in IAC number 1594/2021. Arising out of WPC number 3550/2021. The said post has been directed to be held by the Inspector of Schools, under whose jurisdiction the school is situated. Stop. It may also be pointed out that the said order dated 27/9/2022 has also been sought to be vacated. The review is filed by whom? Petitioner.
The review is filed by the who was respondent in the writ petition, my lord.
Petition number 3550
3550.
has sought to be, what did I say? Has also been sought to be reviewed by the respondent,
Review petitioner who was the respondent in WPC, private.
by the private respondent
In WPC number.
in WPC number 3550/2021 by filing review petition number 77 of 2023. To stop, the review petition is pending as on today. And this court had directed the learned standing council BTC to obtain instructions. Stop. As can be seen, the instructions produced by him has been reflected in the first paragraph of this order. Next para. The said instruction dates back to 2/4/2024. While we are currently in mid-September 2024. Stop. It may further be noticed that this court, in its order dated 27/9/2022, in IAC number 1594/2021, taking into consideration the submission made by the counsel for the department, counsel for the secondary education department, that the matter is being considered at the government level. No, rephrase that. The matter regarding creation of post is considered at the government level, and the school education department is pursuing the matter with the finance department. To stop. It was on that basis that you cancel, and also having regard to the dispute being raised by the by the teachers concerned to hold the post of principal on in-charge basis, that this court had directed the post of principal be manned by inspector of schools under whose jurisdiction the school falls. Stop. However, since 27/9/2022, it appears that no developments, no fruitful development appears to have taken place. In finalizing the creation of posts of principal of the said school. No one is there for school secondary education? Yes.
This letter has escaped your lordship. We have made this matter, your lordship. Kindly shortly it may be given, your lordship. On the next, your lordship will apprise the latest instruction, your lordship.
Mr. Chisti? No, it's okay. Now, you see, in the year 2022, you had made some submission, which I just recited in the order. That the government it's being pursued. It's regarding creation of a post of principal under the BTC. So at that time in 2022, you had submitted that you're pursuing the matter. School Education Department is also approaching the Finance Department to clear the matter. What has happened today, we don't know. So this is the thing. I was thinking of having the secretary. Now, this is a review petition also.
Right.
Now, review petition,
But there may not be any required any interference, my lord. Otherwise, my lord, the point with which the review is to be sought is the judgment of a coordinate bench, which says in that case, it was given to the ADC education. In this case, lordship has, direction is given to the inspector of schools. And lordship, I have placed on the last occasion division bench judgment of this honorable court along with a coordinate bench judgment. And the notification issued by the government that inspector of school is having the required qualifications.
see, at this stage, we'll keep it pending.
Please keep it pending, man. Let the matter review petition be kept pending.
Next para, Mr. SMT Chisti, Learned Standing Council, Secondary Education Department, submits that he may be given some time to obtain instructions in the matter. Stop. In view of such submission and for the ends of justice. 2 weeks' time? 2 weeks' time is granted to the school to the Learned Standing Council, Secondary Education Department, to come up with up-to-date instructions in the matter. Let the matter be listed again on. Today is 13th.
Let it be after vacation.
30th of September.
Yes, sir. I'm sorry.
Obliged.
Respondent and the applicant. May please, your lordship. My lord, I am appearing on behalf of the of respondents 131, numbering 131. We filed an IA for vacating the interim status quo order. My lord, the
You're for the private respondents
private respondent.
in both the writ petitions.
Yes, my lord, no, my lord, in one case, my lord.
In which writ
In
petition?
my lord, 2785/2024.
Item 50.
Yes, my lord, 131. My lord, out of 150, at this stage, we are appearing on behalf of private respondent number 131. And we filed this IA for vacating the interim order against us, my lord, stopping our my lord, training classes going on. My lord, the ground of my lord, challenge of our selection and admission.
Okay,
is
so
taken,
so why is it listed today?
my lord,
It's come up for orders.
It is in the order. Then lordship may fix another date in the next week for stay vacation consideration of our interim order.
See, another date is why is it listed today?
Well, it is in order, my lord.
For what purpose?
Maybe, my lord, for service reports in the main writ petition.
Service for respondent number 150, 155 not completed.
Some of the private respondent have not appeared. They are likely to appear, my lord.
Private respondent numbers?
155
In which case?
in first case, 50, item 50. And item 51, service is completed, Lordship. I have filed one exhibit yesterday again.
Services on respondent number 11 is not complete.
155
11, 150.
and 155.
From where you're saying that?
Office note I have seen, Lordship.
Who's for the petitioner?
I'm for the petitioner.
See, you have been directed by the Lawzima Code to obtain instructions regarding the proper address of respondent numbers 150 and
Yes, Lordship.
155.
Yes,
You,
Lordship.
do you have them?
Yes, Lordship. We are trying to contact with them, Lordship, to give us the proper address. Lordship, so that we'll be able to take fresh steps, Lordship.
When can you take the steps?
Lordship, kindly give us 2 weeks, Lordship.
2 weeks.
Yes, Lordship.
We have, my lord, objection, my lord, such long, my lord, date, my lord, because we are undergoing classes. And our classes have been stopped. We have stopped to continue the training classes.
We have
So we
also
are seriously
urgency, Lordship.
digitized.
We have also urgency because training course is now.
What is the matter regarding?
RCC training, Lordship.
RCC training for.
Latmandal training.
for Latmandal.
RCC training for
Latmandal.
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 Yes, Lordship.
When is the training supposed to start?
Well, it is from January 17 to my lord, July. 6 months training.
This coming January.
Yes. Last January.
So-
Last January it was started. We are admitted. We are undergoing classes. Then my lord, this order, my lord. Because of this order of this court, our classes are.
No, Lordship. It is because the list of candidates were not approved by the Assam government, Lordship. Whereas we were selected by the BTC and as well as we were approved by the Assam government. Lordship, when we were directed to go for training, when we went there, the respondent number 4, that will be the principal of the training center, he stopped us, stating that there's already candidates who are going through training, which is their candidates, but their candidates were not approved by the Assam government.
So court has stayed their training.
Yes, Lordship.
Not state Lordship, status quo was granted, Lordship.
Absolutely wrong projection, my lord.
Let me explain.
My lord, the selection has been, our selection has been taken by the resolution of the BTC. And through advertisement and selection. And their selection was without any advertisement, without
Okay.
resolution of the BTC.
What is the current status now?
Current status, my lord, we are undergoing training, but because of the order, our training classes have been stopped.
Stop.
Yes.
Order was status quo.
Lordship, actually status quo
Because
was
of the
granted.
status quo order, my lord,
So status quo doesn't say stop.
we should continue.
Actually,
Training.
on first day of motion, Lordship, status quo was granted, Lordship. But on the same day, they showed that class has been stopped, Lordship. And BTC authority has selected this batch, Lordship, through proper advertisement and selection process. And petitioner in WPC 387/24, which are the petitioners, they were not selected through advertisement, Lordship. Therefore, second batch is the genuine batch, Lordship.
Okay. All of you are arguing on the merits.
Right.
Now, is it listed for orders today? Now, unless the notice is complete upon the respondents, how do we proceed? This is the thing. So respondent numbers 11, 150 and 155
Yes, Lordship.
are the ones who are left out.
Yes.
So what to do about this?
Lordship, I'm praying for segregate the two matters, Lordship, then it will.
Segregate the two matters.
That will not, this is, my lord, my lord.
Because
Because-
in item number
Because issue is same.
387/24,
Issue is same. It should remain. intact.
issue is same, but 387 is completed, Lordship. Service also completed and pleadings also completed.
So, Mr. Counsel, tell me what can be done?
So item number 51, that is
Majority has appeared. Only 3% left.
That is 387, Lordship. We kindly grant us some time, we will file objection, Lordship. In regard to item number 51, Lordship. That is, and 50, Lordship. We will, as soon as we get the address, Lordship, we will take steps.
51 reply has been filed by them, lordship, and yesterday I have filed another affidavit, lordship, because one honorable high court's order was there, lordship, so I have filed.
51, there are no private respondents, it seems. Item 51.
My lord, in item 50, only 3 persons are left and the others have appeared. Some of the respondent, private respondent appeared through us.
Segregate করিলে হয় বা কথা বলবে। Otherwise it is not- দাদা, segregate কৰিলে আপোনাৰো পাৰপাছন হ'ব। Segregate কৰিব কম। এইটো হৈ থাকিব পিছত। নহ'লে কথা নাই না। Segregate কৰিলে আপোনাৰো ছাৰ।
পার্টি হলে তার সাথে কথা বলবো।
মই কৈ আছো আপুনি। ঠিক আছে।
So let them take steps on this 11, 150 and 155 within a week's time,
Yes, Lord.
within 1 week. Then we'll post this matter
Right.
after 2 weeks. After 2 weeks.
This will should come before vacation. Man.
Please write down. It appears from the order dated 38/2024 of the Lawazima Code that notice upon respondent numbers 11, 150 and 155 is not yet complete. Stop. Learned counsel for the petitioner, Mr.
Yes, sir. Yes, sir.
A. Saranya. Prays for a week's time to find out the correct address and take fresh steps. Praise aloud. Let the matter be listed again after 2 weeks.
That may be fixed, lords. Who is-
30th September.
Diploma.
Interim may be continued, Lord.
Interim order passed earlier shall continue till the next date.
Hello, Lord.
May it please your lord.
Yes.
My lord, in this matter, my lord, we have been newly included. If your lordship will kindly see the last order of 3/6/2024. That copies of the amended petition was to be served upon the newly included respondents, my lord. 5, 7 and 8. We have not received any copies, my lord. So we could not take instructions.
Regular voting bill are going.
You are for 5, 7 and 8?
I am for 8.
I am appearing for 5.
5 and you're for
I am
8.
for 8.
What about 7?
7 is
Nobody.
industries, madam.
Industries.
Industries, madam.
Industries Department.
Yes.
Yes, Mr.
Lord, this case relates to, my lord, the payment of retired benefits to the, my lord, petitioner, your lordship. And there is already an, my lord, order dated 21/9/2017, your lordship. passed by this honorable court directing the, my lord, respondent authorities, my lord, to pay retire, my lord, this gratuity.
No, we are talking about the copy. When are you going to serve the copy? This respondent numbers 5 and 8.
Now they are implemented, my lord, I do not know. Huh? My lord, we have filed, my lord, this additional affidavit, your lordship will find, my lord, on 14/5/2024, your lordship.
No, just a minute. You're impleted by which order? You have filed an amended writ petition award.
Yes.
When was it filed?
Now, after passing of this order, my lord, they received the, my lord, the Hindustan Paper Corporation, they received the order. And they said, my lord, this, these are being paid, these are being processed, my lord, in the departmental laws. And in thereafter, my lord, in the meantime, my lord, this employer, Hindustan Paper Corporation, my lord, it went into liquidation. And my lord, it was a central government undertaking, my lord, and accordingly, the government of India, my lord, issued a notification, your lordship, 2nd of July 2019, stating that, my lord, my lord, dues payable to the employees in consultation with the administrative department should be paid, your lordship. Nothing was done. And thereafter, my lord, one Kuldeep Verma, my lord, he was appointed as the liquidator. He is a party in the proceeding, my lord, petition. But he had also done nothing. And then, my lord, this particular, my lord, Hindustan Paper Corporation, Kachar Paper Mill, my lord, at Pajgram, Hailakandi district, was taken over by the Assam government, my lord, through their instrumentality, my lord, Assam Industrial Corporation. Now, my lord, Assam Industrial Corporation is to pay the retirement benefits of the petitioner, your lordship.
Mr. Dhar,
Nothing is being done.
Mr. Dhar,
Well.
see, you serve copies to the newly pleaded respondents. And then they'll let them get instructions. Please write down.
তোমরা কিচ্ছু করতে পারবে না তোমাদের পিটিশনের কপি পেজ নাম্বারও নাই নাথিং ইজ দেয়ার সো তুলে দিল petitioner retired, my lord, in the year 2015-13.
Department of Industries. What is the department called?
Department of Industries and Commerce.
Department of Industries and Commerce.
Assam
And the other one?
Development.
Who's the other? Huh?
I am for the official liquidation. Respondent number 5. Kuldeep Verma. Respondent number 5 in the newly implemented petition.
Where are the names?
কি বলবো এটা কি বলবো আমি এটাতে কি আর্গুমেন্ট করবো উঠে গিয়ে আমি দেখতেছি এখানে কোনো পেজ নাম্বার নাই কোথায় গুড করো না
The last order is appears.
You just find out, just show it to me.
আমি এখন দেখাবো কি করে পেজ লিস্টিং আমি আর আসতে না বলছি করে না উঠিয়ে যায় কে বলছি তোমাকে রেজিস্টারের দিকে কে বলছে রেজিস্টারের তরফ থেকে
7 and 8.
8, madam.
You're for 8.
8. He's for
And you're
6.
I am for 5.
You're for 8, he's for 5. And what about 7?
Seven, council is not present, my lord, at this meeting.
Both of you have not received the copy.
Yes, yes,
You have been impleted as party respondent.
yes.
By which order?
28 2, my lord. 28 to 2024.
The respondent number, please write, respondent number 5 and respondent number 8 were impleted as party respondent. White order dated 28/2/2024, passed in IAC number 444/2024. Stop. The learned counsels representing the respondent number 5 and 8 submit that they have not received a copy of the writ petition, and therefore they are unable to obtain any instructions in the matter. Counsel for the petitioner shall furnish a copy of the writ petition each to Mr.
Yes, that's my lord.
S. Das, counsel for respondent number 8, and Mr.
P. Chaudhary.
P. Chaudhary, learned counsel for the respondent number 5. Within 2 days. Let the matter be listed again.
After vacation, my lord.
After vacation.
Yes, your lordship, yes, my lord.
You're out station, isn't it? You said you come back after puja.
Highly obliged.
List again after the ensuing vacation.
Me.
Yes.
Today I filed, a affidavit in reply. The affidavit may be requisition, my lord, the matter may be taken on twice today.
On. May be taken on. Counsel for the petitioner, please write. Submits that he has filed the rejoinder affidavit this morning. Stop. The same is, however, not on record. Office to verify and connect the same to the record. List the matter again.
One.
After a week.
Lordship, here in this case, Lordship, I have some limitation, Lordship. Here I have to file an affidavit, Lordship, in 3 cases, Lordship. And therefore kindly fix the matter after vacation, Lordship. I will file the affidavit in the
After
meantime.
vacation is too long, my lord.
After vacation means I have to sort for instruction and prepare my affidavit,
Matter
Lordship.
of 2019. my
Lordship,
lord.
fix the date, Lordship, immediately after vacation, Lordship, kindly fix the date.
What is your good name?
J.K. Goswami, Lordship.
Mr. J.K. Goswami, learned counsel appearing for respondent number,
Forest Department.
Forest Department.
appearing for the forest department. Submits that he may be given some more time to file counter affidavit. Say prayer is not objected to by the other side, learned counsel for the other side, but they pray that a short date may be given. In view of above, let the matter be listed again.
Again, my lord, before vacation, my lord, if they take,
No, before vacation.
if they cannot, my lord, they will take time, my lord.
Not before vacation, can you fix the matter immediately after the vacation, Lordship?
Lordship,
Any
can
date,
it be a 4th October, my lord? If they cannot file, my lord, they will take adjournment also.
But adjournment, continuous adjournment will difficult, Lordship.
Anyway, my lord, I'm leaving up to your lordship, my lord.
Can you fix it immediately after the vacation, Lordship? Any date, Lordship.
23 तारीख में है की
Oh, test take lo pora. 23 Lordship.
On
October
23rd of October.
My lord, in the absence of my lord, affidavit matter has to be proceeded.
No,
That
I will file.
observation
I will file.
Time is granted with the understanding that the forest department shall positively file the affidavit
Lordship.
by the next date.
Lordship.
Item number 8, 9, and 10 are connected matters. All these 3 petitioners, they are contractual employees, my lord, working under the National Health Mission. In the year 2019, my lord, their services were terminated based on the performance appraisal report that was conducted by the state authorities, my lord. Now, our contention before this honorable court was that the performance appraisal was conducted
in violation of the rules and procedure that was holding the field. And these petitioners, my lord, they were apprised very highly by their controlling officer, and at the state level, that rating was lowered. So in that view of the matter, our contention was that this is a flawed appraisal, and prima facie, your lordship had dealt with the matter at that point of time and stayed the termination orders, my lord. Now, after that, my lord, all along, the performance of the petitioners have been rated very highly, my lord. In item number 9, my lord, the petitioner has all along been rated in the B category. In item number 10, on one occasion, he has been rated in the A category. The other two occasions, he have been rated in the category B and C. Now, in the meantime, the government has also done away with the policy of terminating contractual employees, my lord. Since they are already serving and the appraisal was, since it was flawed, my lord, they have already got some instruction probably on the direction of this honorable court regarding the appraisal. So may I pray that these matters can be disposed of, my lord, by setting aside the termination order, and they may be allowed to continue, my lord.
What is the post?
The district program coordinator and district, in my case, my lord, one is the district program coordinator and the other one is district media expert. Prima facie, my lord, on records, it can be shown that the
District media expert
in item
under the NHM.
NHM. In item number 9, he was the petitioner is the district program coordinator. My lord. In fact, at the motion stage, lordship had granted the stay order.
By which order?
My lord, in item number 8, first order, lordship will find that. And that order was followed in item number 9 and 10.
There are several posts, not just these 2 posts.
My lord, in this case, my lord, only 3 petitioners are concerned.
Which case?
In these 3 cases, my lord, if lordship takes up item number 8, my lord, 9, my lord, I can show that order, my lord, page 44. In this case, the petitioner is at serial number 11, and in item number 10 is the number 1 is the petitioner, my lord. One, 9, and 11 are the petitioners in these cases. Last page of the petition, page 44.
Page number?
Page number 44.
44.
44 of writ petition number 506 of 2009. The person at serial number 1 is the petitioner in item number 10. Person at serial number 9 is petitioner in item number 8. And at serial number 1 is the petitioner in item number 9.
And item number 9 is 506.
506.
Yes, 506, we're holding that. What is the name of the petitioner?
Syed Mehndi Hussain.
Is that serial number 11?
Yes, he is at serial number 11.
District program, only one petitioner.
Yes, yes. There are only one petitioner in all of the cases. In item number 1, my lord, there are 3 petitioners.
Item number
8.
Sorry, what you're saying?
In item number 8, probably my learned brother is appearing, there are 3 petitioners.
For item 8.
Either you stick to the item or to the writ petition. Don't keep on reciting both together. Sometimes item, sometimes serial number.
Well, sorry.
See,
She was taking item number 9, my lord.
613. 613 is also one single petitioner, is it?
613, yes, single petitioner.
Name of the petitioner and his, sorry?
Rubul Das. Rubul Das is serial number 1 in page number 44.
44.
Yes.
You are appearing in this case also.
In this case, in these two cases, I am appearing, my lord.
Rubul Das, serial number 1, isn't it?
One.
This is what? District Media Expert.
Expert.
And the other one was District Program
Coordinator.
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 Okay. So these are single petitioners.
Single petition.
Now, in the third case, that is WPC 287.
My brother would be appearing.
In here, in this case, there appears to be a lot of posts. That's why I was indicating. This is not only this district program coordinator or media expert. They comprise of PHC accountant cum assistant block program manager, block program manager, block data manager. How many petitioners?
In item 8, Lordship, 3 petitions.
Where is the appointment order?
Appointment order is in, Lordship. Um, 21, page 21.
Appointment is together or separately?
Separate, Lordship.
Separately.
Yes, they are all serially.
Page 21.
It starts from 21, Lordship. Until 25, Lordship.
This is petitioner number?
At 21 is petitioner number 1, Lordship.
Then?
At 22 is petitioner number 2. And at 24, Lordship, petitioner number 3.
Nishanka Bor Pujari.
Lordship.
Together, altogether, 3 petitioners.
3 petitions.
These are contract appointment, isn't it?
It is.
And how long does this contract period is supposed to last?
Now, Lordship, according to the new contractual engagement, it is indefinite. Lordship.
Up to
Sorry?
60 years.
Up to 6 years.
Up to 60 years.
It has been modified that
As per which provision?
there's a policy adopted by the government of Assam, my lord.
No, have you brought that into record?
At that time it was not there, my lord. Subsequently, it has come in my learning.
That's why subsequently you're supposed to bring that on record, saying that this is the,
That
We have not
policy,
been-
yes, Lordship.
We have
That
not
would
been
be with
handed over
the
with
State
by
Council, Lordship.
State Council.
The Council for Health Department, Lordship, they will have that policy, Lord.
they will have it, but you know it also. You should have a copy.
We have not been handed over a copy. That's the difficulty. I have asked for, my lord.
You have not seen the copy.
They have seen, but they could not lay their hands on it, my lord.
Yes.
They are not parting with it. That's the problem. Anyway, my lord, that they have already done away with the system of termination of contractual employees, my lord. It's an admitted thing, my lord.
What have you impugned in this writ petitions?
Their appraisals, my lord. In that page
I
40,
petition, Lordship, the
Where?
termination order
Where?
at page 45,
44 and 45.
44 and 45, Lordship. This was staged, Lordship, by this honorable.
So appointments of the petitioners are basically in the year 2008, 2007 and one is 2013.
Yes, Lordship.
Then you have been sought to be discontinued by the impugn orders. This was states. And the grounds taken for discontinuation of your service is on the basis of some appraisal report.
Yes. There was supposed to be, Lordship, two levels of appraisal, district and state. In my case, Lordship, only district was done and the state level appraisal was missing, Lordship, which was supposed to be a part of the procedure. And that is why, Lordship, this honorable court in 18/1/2019 gave us the interim protection, which has been extended till date, Lordship. The observation has been recorded there.
Yes, what do you say, ma'am?
We have not received the fairwise comments, my lord, details, so could not file the affidavit in opposition, my lord. Some instruction is there, my lord.
Would you like to explain what kind of instructions you have passed on to this court?
Yes, my lord. As
Yes.
per in pursuance of the order of this honorable court, my lord, they were reinstated in their service, my lord. They are continuing and after, my lord, thereafter their performance appraisal has been measured, my lord, where they are done better, my lord, and they are accordingly they are continuing in their service, my lord.
So how do we understand this instruction of yours?
Lordship, if I may. So, Lordship, now the petitioners are still working with the department and they have been receiving latest appraisal reports, which are very good, Lordship. And that is why, Lordship, the impugned order in this petition can go away, Lordship.
You are continuing on the basis of the
Okay,
interim order passed by this court.
Yes, but appraisals are also given, Lordship, that they have been working satisfactorily.
Can we dispose it of? Heard, Mr.
I bought.
I, Bo Thakur, learned counsel for the petitioners in WPC number 287/2019, and Mr.
B. Sharma.
B. Sharma, learned counsel appearing for the petitioners in WPC number 506/2019 and WPC number 613 of 2019. Stop. Since the issue involved in all the three writ petitions are similar and identical, they are being taken up for disposal by common order. Stop. Next para. The case of the petitioners is that they were appointed either as district program coordinator, district media expert, PHC accountant assistant block program manager, block program manager, and block data manager under the National Health Mission (NHM) by the mission director, NRHM, Assam, and secretary to the Government of Assam Health and Family Welfare Department. On contract basis. According to the petitioners, their performance of work are to be assessed at two different levels, namely by the district
State level.
scrutiny committee
At the district level as well as
at the
state
district level, and then by
State
the
level.
state level, and at the state level as well. Stop. According to the petitioners, although favorable appraisals have been made by at the district level, but the same have been downgraded at the state level, and for which reason the impugn orders to discontinue them from service have been issued by the respondent authority. Stop. It is also the case of some of the petitioners that their appraisals did not reach the state level. And without there being any scrutiny by the state, their services were sought to be discontinued. To stop. Aggrieved, they have approached this court. Stop. Next para. This court, while issuing notice of motion on 18/1/2019, had given an interim protection to the petitioners in WPC number 287 of 2019. To stop. Similar orders were passed in the other two writ petitions, which were filed subsequent to WPC number 287 of 2019. Stop. It is the submission made. It is the case. No. Cancel that. The learned counsel for the petitioners submit that pursuant to the interim protection given by this court, the petitioners are continuing with their work, and there has been periodical assessment of their performance at the district level as well as at the state level, and that the respondent authorities, being satisfied with their performance, are continuing not only by virtue of the interim order of this court, but by virtue of their performance as well. Stop. It is therefore their submission that the interim order passed should be made absolute and the writ petition be disposed of. Next para. Miss
A. Bora
A. Bora, Learned Standing Counsel.
for NHM, National
it-
Health Mission.
Is it NHRM or NHM?
Earlier it was NHRM,
Now-
now it's NHM.
Okay. Learned Standing Counsel, NHM, submits that although the NHM has not filed counter affidavit, but she has received some instructions, which is to the effect that the petitioners have been the services rendered by the petitioners have been scrutinized periodically. And on the basis of on the basis of their performance, their services have been renewed from time to time. Before this, you write, okay, Miss So-and-so, and the Standing Council submits that. Arhan Belro submits that in view of the interim order passed by this court, the petitioners have been allowed to continue in their respective services. Stop. She further submits that.
She has received some instructions which is to the effect that the petitioners having the services rendered by the petitioners have been scrutinized periodically, and on the basis of their performance, their service have been renewed from time to time.
Stop. Next para. Upon hearing the learned counsels for the parties and upon perusal of the materials available on record, including the instructions received by the Learned Standing Council, NHM, this court is of the view that the respondents also appear, the respondents only appear to be satisfied with the performance of the petitioners, which has been assessed from time to time, and by virtue of which the services have been continued, notwithstanding the protection which is already given by this court as well. Stop. Accordingly, the writ petitions are disposed of by making the interim order passed earlier absolute. It is, however, provided that what should we observe?
That order,
Sorry,
order has to go, my lord.
the impugn orders are also the impugn orders passed by the respondent authorities are also interfered with. To stop. The petitioners will be allowed to continue in their respective service in terms of their respective contract agreements and as per the policy in force.
Much obliged.
Okay. I'll come back in 5 minutes.
Harmonize with the deceased husband after his retirement. This is the basic question.
So name is not entered in the service
Yes,
book.
my lord, entered. On the facts of this matter, my lord, the petitioner's husband, my lord, he was a grade 4 employee, my lord, of Guwahati University, my lord. He was retired from his service on 1/7/1995, my lord.
Yes.
1/7/1995, my lord. And subsequently, my lord, in the month of June 1996, the first wife of the expired, my lord.
Yes.
And subsequently, my lord, on the September 1998, my lord, he solemnized second marriage with the present petitioner, my lord.
Which date?
With September 1998, my lord.
There's no date?
Date, my lord, no date was there, my lord. September 1998. And my lord, on 4/5/2006, my lord.
4/5?
4/5/2006. Petitioner's name was incorporated in the pension paper.
Petitioner's name.
Yes, my lord, that, my lord, that she is a legally married wife, my lord.
Who's the petitioner here?
Petitioner is the, my lord, present petitioner, my lord.
Yes.
So, wife of the deceased. Present petitioner, my lord.
Okay, Srimati.
Yes,
Debo.
Srimati.
Name was entered in the service book.
It is not service book, my lord, in the, my lord, the pension paper, my lord.
Name of the second wife.
Yes, my lord, the present petitioner, my lord.
Yes, then.
Yes, then, my lord, on 29/11/2016, 17, my lord. The husband expired, my lord. Then on 27/4,
Just a minute, let me repeat.
my lord.
4/5/2006. Name entered
Yes, my lord.
in the
In the pension paper, my lord.
pension paper.
Yes, my lord.
What is that pension paper?
My lord, page 14, lord. That page 14, my lord.
Photograph is also there.
Yes, my lord.
What is this? What is this thing?
Then, my lord, they entered that Nobin Chandra Das remarried after first wife expired and married after retirement. Right hand side, my lord. Top, my lord. Page 14, my lord.
Who has written this?
My lord, this is the treasurer, my lord, Guwahati University.
This is from the treasurer to the petitioner. Petitioner's husband.
Yes, my lord.
Address to whom?
Address to the people, not a deceased, my lord.
Deceased.
Yes.
Nobin Chandra
Da-
Das. This is letter of 1996.
Yes, my lord. Then, my lord, on
No, just a
29
minute. You said 1996.
No,
This
my lord,
is
that letter was issued, my lord, on 1996, my lord, the first letter, that, my lord, but on footnote, my lord, it is 4/5/2006, my lord.
no. Are you still at page 14?
14, my lord, 1/4, my lord.
From where do you get the date?
My lord, that is that signature and date, my lord. On the right hand side, my lord, top.
4/5/2006.
Yes, my lord.
Then the letter, the date given in this letter.
Yes, my lord.
The date of the letter, the date of this letter is what?
Yes, my lord, it is
2396.
1996, I think.
23/1996. And on top of that, somebody has entered here
Yes, my lord.
as 4/5/2006. Who has done this?
My lord, the second treasurer, my lord.
But where is the signature and seal?
Signal, short signature is there, my lord.
Okay, then
Then, my lord, husband of the petition expired on, my lord, 29/11/2017, my lord. That certificate is annexed on page 15, my lord.
15.
Then, my lord, subsequently, my lord, on 27/4/2018, my lord, the petitioner submitted a representation before the registrar Guwahati University, my lord. It is page 16, my lord, translated copy at page 16 and original at 17, my lord. And, my lord, then in that letter, my lord, that in footnote, my lord, marriage after retirement will not be recognized, my lord. They have given a footnote, my lord.
Where is that?
My lord, top of the page 17, Lordship. Left hand side, my lord, original copy.
This petitioner's application is addressed to whom?
The registrar, Guwahati University.
Where is it written? Something missing in the translation.
Address is sorry.
Address is registrar, otherwise.
Yes,
Okay.
The registrar, Guwahati University. But it is original copy there.
So this application was made on 27
for 2018.
for 2018 and it was rejected.
In the footnote, my lord, that marriage after retirement will not be recognized.
Yes. What is the date of this signature?
It is the same date, my lord, 27
date.
for 18, my lord.
On the same day of application, it was
Yes, my
rejected.
lord. That is, that
Okay.
your prayer is rejected this. So, my case is very simple, lordship, that the service of the petitioner or the employees of the Guwahati unit also governed by the Assam Services Pension Rule 1969, my lord. So, I have written that page 6, my lord.
Page 6.
Page 6, my lord, paragraph 8. May I read, my lord?
Yes.
That your petitioner states that the Assam Services Pension Rule 1969, which was enacted to deal with the issues relating to the pension of the employees of Assam, was also adopted by the Guwahati University. Thus, the Assam Services Pension Rule 1969 herein are referred as rules govern the issues relating to the pension of the employees of Guwahati University. Rule 143 of the aforesaid rule deals with the family definition, which is as follows. That family for the purpose of rules in this section will include the following relatives of the officer: wife in case of male officer, husband in case of a female officer, minor sons, and D, my lord, unmarried minor daughters. Note 2 is important, my lord, 2A, small a. Marriage for purpose of admissibility of pensionary benefit to the spouse of a retired official shall mean marriage before or after retirement.
Let us see the Assam pension rules.
Yes.
1969. ठीक है, sir. You are relying upon note 2.
Yes, madam.
What do they say in the counter affidavit?
My lord, there is nothing, my lord, vague affidavit, my lord.
There's one more issue which can be also considered. Supposing the government, the petitioner on the husband, late husband,
Hello.
was a bachelor.
Yes.
He retired as a bachelor. And after retirement, he got married. Then his wife will be entitled to pension.
Then also, my lord, because my lord.
There is one thing, but the other thing is he had a wife, but a wife died after retirement and got remarried again. So
Male, my lord, male. My lord, that incumbent is male, my lord. No. The employee is male or female.
correct.
Fine.
The employee is male.
Male.
So this rule says that it shall mean marriage before or after retirement?
This honorable was already, but that issue has already been, one decision is there. 11%, 7 and 8, my lord.
Mr. Sharma, what do you say about this judgment? How do you explain this judgment?
My lord, that regarding, my lord, that in this matter, my lord, petitioner was denied family pension on the ground that marriage took place
After retirement?
after retirement.
There's something regarding here.
18/1/95, my lord, that amendment was made on 18/1/1995, my lord. So, my lord,
Amendment of what?
that regarding, my lord,
Where's the amendment provision? 18/1/1995.
yes, my lord.
Do you have it?
With effect on. So in our case, my lord, that date is not the problem, my lord, because our.
No, it's
marriage
okay,
was-
but I just want to know what is this amendment?
Yes, my lord.
What is this amendment about?
My lord, that
Is it available in the book?
yes, my lord.
Just show me.
That note 2, my lord, substituted note 2, rule 143(1). That note 2, my lord.
Note 2, though you have abstracted. Note 2 has been inserted
Yes, ma'am,
by this amendment.
by this amendment. 143.
Where is that? Just show me.
142. note 2 substituted, my lord. Rule 143 2A.
Hmm? Where?
Down below. Down below, my lord.
You are referring to 143.
My lord.
This note 2 has been inserted.
Yes, madam.
This was as per the notification of 9th August 2018.
No, madam, 18/1/1995.
9th August 2018.
No, madam. It is 18/1/1995, madam. 18 January 1995. Substituted note 2 of rule 143(1), hide notification number PPZP 148 and dated 18 January 1995. No.
No, against that note 2, there's a figure 1. That figure 1, you get in the footnote.
Hello.
In the footnote, serial number 1 is 9th August 2018. Are we holding the same
No,
book?
different book, madam.
Give me that book. There must be some typing error also, I don't know. It is correct in your book. In my book, it's different.
No.
That small 1 is given against that note 2. That 1, it relates to a certain notification dated 9th August 2018. Yes, even that.
So, madam,
That is your case.
So judgment is also, my lord, same.
In the judgment, what it says that
No, my lord,
constable married after the retirement.
second marriage.
This was a second marriage.
Yes.
No, in this
No,
judgment.
not second marriage, my lord.
In
but
this
after
judgment.
retirement, sorry. Because the pension was denied because that marriage was solemnized after that amendment, man. Before amendment, sorry.
Oh, yes, that is
Before
the
amendment.
that is the crux of the matter.
But my lord, in my case, my lord, that point is not there. my lord.
Question was, she would have been entitled
Right.
if she was married before the amendment.
And
No, I mean, sorry, married after the amendment.
Right.
Marriage was before the amendment, so not entitled.
But
But the
Malad-
court said that it cannot be so.
Nothing before or
Ah.
after. Because, my lord, that this is received pension until his return, the date of expiry, man.
What is this? DS Nakara.
My lord, it is a
One judgment referred to
Yeah,
here.
Supreme Court judgment, my lord, constitutional bench.
What is the law laid down?
Another one, the apex court judgment, my lord, where, my lord, the apex court held that family pension, post-retired spouse, offspring, exclusion from the definition family held unconstitutional.
Sorry?
So, my lord, and that CCS pension rule, originally that in the, my lord, definition of family, that, my lord, post-retired spouse was not there, my lord. But the apex court held that it is unconstitutional, not inclusion of those, my lord. This 89 judgment, my lord.
What is the relevant para?
So 11 para, my lord, 9 and 13, my lord.
Benefit of income has been extended, not just. This is with regard to the CCS pension
Yes,
rules
sir.
1972.
Yes, ma'am.
Now, in your case, what is the rules applicable?
But that is, my lord, Assam pension, Assam Services Pension Rule 1969.
Assam Services Pension Rules 1969. Okay.
And my lord, Rule 143.
So after the amendment, it does not distinguish.
Yes,
You can. Yes, Mr. Phukan.
Stop. My lord, the facts of the case, my lord. Now I take your lordship straight to paragraph 4. 4 to 7
Of the writ petition.
of the writ petition. Married. The dates are important, my lord.
Yes.
Page 4, paragraph 4, 5, 6, 7. That your petitioner states that in the month of September 1998, late Nobin Chandra Das solemnized his second marriage. It is after retirement. With your petitioner. Thereafter, her name was incorporated in the pension paper on 4/5/2006. Marriage was solemnized in September 98, and pension paper, her name was incorporated after 8 years, Miller, in 2006. Being the legally married wife of late Nobin Chandra Das in place of Srimati Bimala Devi since expired. The said correction was made. It is very, very important, Miller. I have indicated in my affidavit in opposition, Miller, regarding footnote aspect. Footnote aspect, Miller. Notings in the file, footnote, whether it is legally acceptable, Miller. And as per the Honorable Apex Court, Miller, it cannot be acceptable if it is not converted into an order, and that too shall be communicated to the person concerned. There are two elements. One, it would have to be converted to the order, and then it would have to be communicated to the person concerned. Anyway, the said correction was made as a footnote in the body of the letter issued by the memo number so-and-so dated 23/1996. The letter was of 1996. Marriage was of 1998. and pension paper correction was in 2006. Under the signature of Treasurer, Guwahati University. That next paragraph. That your petitioner states that unfortunately on 29/11/2017, the husband of the petitioner Nobin Chandra Das was expired, and accordingly a death certificate was issued under the signature of register birth and death so and so Goftabasa. Next page. Paragraph 6. Your petitioner states that after death of her husband, the petitioner on 27/4/2018 expired in 2017, and in 2018 petitioner approached, submitted an application before the registrar Guwahati University, praying for release of her family pension, being the legally married wife, late Nobin Chandra Das. The respondent authority on submission of the said application dated 27/4/2018 immediately informed her by putting a footnote, again footnote, my lord. In paragraph 4, my lord, that footnote, my lord, of correction. First wife and second wife now informed her by putting a footnote in her application that marriage after retirement will not be recognized for purpose of pension rule, and thus she is not entitled for that. In the said footnote, it is also stated that the said decision was taken as per Executive Council Resolution so and so dated 14/8/1982. Now paragraph 7. Your petitioner states that on receipt of the aforesaid information, whoever the respondent authority refused to sanction and release the pensionary benefit to your petitioner, allegedly on the basis of an Executive Council Resolution dated 14/8/1982, your petitioner submitted an application on 4/12/2018 to the respondent number 2, that is the registrar of the university, under the provision of RTA Act 2005 to know the information regarding Executive Council Resolution by the resolution number so and so dated 14/8/1982. In response to the said application, the respondent authority on 21/12/2018 informed your petitioner that there is no executive, next page, my lord, there is no Executive Council Resolution by the resolution number so and so dated 14/8/1982. My lord, these facts, my lord. Now, if we turn to page 14, my lord, the footnote in the pension paper, whether it should be termed as pension paper or not, it is another aspect, my lord. Annexure A, page 14, my lord. Down below the signature and the date is of 20th March 1996. And most importantly, the first wife expired in June 1996. It was issued in March 96. First wife expired in June 1996. And second marriage solemnized in 1998, after 2 years. Then the husband of the writ petitioner expired in 2017. And the writ petitioner submitted her papers, pension papers, in 2018. Now kindly see the footnote or file notings. First wife Bimala Devi expired. It was some short signature is there, 4/5/2006.
Mr. Bukan, you leave aside the footnote and all that. What is written in the footnote speaks for itself. Nothing more, nothing less.
Milo.
The more substantial question which is involved here is whether the second wife of the employee who was married after his retirement will be entitled to get pension or not. So the note 2 speaks for itself.
Miller, there are two aspects, Miller. First, this footnote aspect, we cannot escape from that aspect. Second, that pension rule provision, Miller. Miller, first, I'm, Miller, focusing upon this footnote aspect.
No,
Milord,
what,
my affidavit.
why do you stress on the footnote?
Milord, if footnote goes, Milord,
No,
then
so
everything goes, Milord.
How?
Milord, since Milord, first wife, second wife, Milord, everything will go, Milord. Since
No.
footnote is not acceptable in the eyes of law. What
No,
Supreme
you,
Court says,
let us ignore the footnote. Let us ignore this application or pension paper, whatever it may be.
then first Milord pension rule.
Let us ignore that.
Milord,
Factual aspects is that the person retired from service on 1/7/95.
but factually, the
His first wife died in June
Milord.
1996.
Milord,
He got married in 1998,
Milord.
second wife.
Milord,
He was enjoying his pension,
Milord,
living with his second wife, but he unfortunately died in 2017.
Milord,
Now the second wife is left without any pension.
Milord.
Question is whether she will be entitled to pension of her husband or whether she'll be entitled to family pension. The pension rule says she can
Milord,
be given.
I will come to now the pension rules, Milord. Before that, Milord, she will have to establish whether she is legally married wife, second wife, and whether in the pension paper, her name has been legally transferred replaced in place of the first wife. If it is not, Milord, then pension rule won't be applicable. Anyway, Milord, I will come to pension.
Then you ask her, if you say that you are married to this employee, give me some certificate as proof of your marriage. Matter ends there only.
Milord,
But whatever is entered in the pension papers, whether entered before or after, or whether it's entered, or whether this is a pension paper at all, let us not go into that. Is it required?
Milord, since Milord, when one files a writ petition, then he or she will have to establish her right. And how the right will, Milord, the writ petitioner will establish, Milord.
The right is established by the pension
The
rules
footnote,
amendment.
Milord. Her writ petition entirely depends upon footnote. And what apex court says, Milord. First, Milord, anyway, Milord, I delve upon this aspect later, Milord. First, pension rule. In pension rule,
I don't
also it's
find-
not in favor of her, Milord.
I have the habit of speaking my mind like that, but
Milord.
it's not that we have decided it finally, but what is there left in the footnote?
Since Milord,
He has relied upon one footnote and another footnote says that rejected. So both are equal.
Milord.
He's saying that as per the footnote, I am also there in the pension paper.
Milord.
But as per the footnote, it is rejected. So both are footnote. So both are equal
if
now.
one footnote is accepted, if it is acceptable in the eyes of law, then that rejection footnote is also acceptable in the eyes of law. It cannot be, Milord. What law says, Milord?
No,
Milord,
rejection has to be.
Only two judgments of the apex court, Milord. That will clarify. Then I will come to pension rule. And
No.
if your lordship, Milord,
Rejection will have to be tested in view of the amendment.
Milord.
As per the amendment, whether that
Milord,
rejection is
pension
correct or
rule
not.
is also against her, Milord.
Huh?
Pension rule is also,
How?
Milord. Milord,
We have seen that.
Milord,
note 2.
kindly turn to page 6, Milord. Paragraph 8. The interpretation is little bit technical, Milord. Anyway, Milord, law is law, Milord. Equity and law, Milord, we will have to go by the law, provisions of law, Milord. Anyway, page 6, Milord. Paragraph 8.
You read that.
Note 2 says, Milord.
Yes.
Note 2A. Marriage for purpose of admissibility of pensionary benefits to the spouse of a retired official shall mean marriage before or after retirement. It goes in favor of the writ petition. Now kindly turn to next page, Milord. Page 7, Milord.
Yes.
2, 143, Roman 2. The pension will be admissible. It is very important, Milord.
From where?
The third line, page 7. Writ petition, Milord.
Third line.
Third line. 143, 2. That was 143, 1, note 2. Now 143, 2. The pension will be admissible. A. Pension, detail.
Boy to dia.
143.1, now 143.2. Small 2, Roman, small 2, my lord.
Yes, read.
The pension will be admissible. A. In the case of a widower, up to the date of his death or remarriage, whichever is earlier. So, my lord, the pension will be admissible up to the remarriage. Then again down below, my lord. Note 4, my lord. In the writ petition, my lord, page 7. In the event of remarriage or death of the widow or widower, the pension will be granted to the minor children through their natural guardian. In disputed cases, however, payments should be made through a legal guardian. These two conditions, my lord. Pension will be up to the date of remarriage. And in the event of remarriage or death of widow, here widower, my lord, pension will be granted only to the minor children. So footnote 2, it goes in favor of the writ petitioner, but this 2A and Roman 4, these two conditions are against the writ petitioner. This is, my lord, one aspect, and the most vital aspect, my lord, I have already pointed out that footnote affairs. That footnote affairs. It cannot be, my lord. My lord, Puranjit Singh, my lord, case. Only one paragraph I will rely, my lord. 1994, 3 SCC 471. Paragraph 11, my lord. I will read the entire paragraph, my lord. Paragraph 11, my lord, page 476, down below 2 lines. The petitioner's seniority has therefore to be counted in his parent department, which is the engineering department of the Chandigarh administration. Next page, my lord. Last page, 477. And he has also to earn his promotions in the said department according to the rules and as and when the appointments are made to the vacancies which become available in that department. He can neither count his seniority on the basis of his service prior to his fresh career as a direct recruit, nor can he claim his promotion on the basis of the post or posts that he had held in the organization to which he was deputed. However, in spite of the clear position in law, he has been pursuing his misplaced claim for counting his seniority prior to his fresh career of assistant engineer as a direct recruit and for promotions on the basis of the promotions which he had earned in the organization where he was sent on deputation. For this purpose, he is relying upon certain notings. It is important, my lord. For this purpose, he is relying upon certain notings either of the chief engineer or the home secretary of the Chandigarh administration. Although it is not known how he came in possession of the said notings, it was improper on his part to produce these notings in the court proceedings, assuming that he had come in possession of them authorized. Now, it is very, very important, my lord, this sentence. As a responsible officer, he ought to know that notings in the department files did not create any rights in his favor. It is the orders issued by the competent authorities and received by him which alone can create rights in his favor. My lord, now a recent judgment, my lord, not so recent, my lord, 2013, 16 SCC. It starts from para 33 to 38, my lord. Para 33, my lord. Union of India and another versus Ashok Kumar Agarwal. The paragraph 33, my lord, page 165. The instant case is required to be considered in light of the aforesaid settled legal propositions, statutory provisions, circulars, etc. The tribunal inter alia had placed reliance on notings of the file. The issue as to whether the notings on the file can be relied upon is no more res integra. Next parameter. In Santi Sports Club so-and-so, this court considered the provisions of Article so-and-so of the Constitution and held that unless an order is expressed in the name of the President or the Governor and is authenticated in the manner prescribed by the rules, the same cannot be treated as an order on behalf of the government. Next para. The court further held that Santi Sports Club case, my lord, a noting recorded in the file is merely a noting simpliciter and nothing more. It merely represents expression of opinion by the particular individual. By no stretch of imagination, such noting can be treated as a decision of the government. Even if the competent authority records its opinion in the file on the merits of the matter under consideration, the same cannot be termed as a decision of the government unless it is sanctified and acted upon by issuing an order in accordance with Article so-and-so, Article so-and-so. The noting in the file or even a decision gets culminated into an order affecting right of the parties only when it is expressed in the name of the President or the Governor, as the case may be, and authenticated in the next page, my lord. Authenticated in the manner provided in Article 77 or Article 166. A noting or even a decision recorded in the file can always be reviewed. It is important, my lord. I have, my lord, quoted these lines, my lord, in my affidavit in opposition. A noting or even a decision recorded in the file can always be reviewed, reversed, overruled, or overturned, and the court cannot take cognizance of the earlier noting or decision for exercise of the power of judicial review. Now, paragraph 36. Similarly, while dealing with the issue, this court in Sethi Auto Service Station versus DDA held, it is tried to state that notings in the departmental file do not have the sanction of law to be an effective order. A noting by an officer is an expression of his viewpoint on the subject. It is no more than an opinion by an officer for internal use and consideration of the other officials of the department and for the benefit of the final decision-making authority. Needless to add that internal notings are not meant for outside exposure. Notings in the file culminate into an executable order affecting the rights of the parties only when it reaches the final decision-making authority in the department, gets his approval, and the final order is communicated to the person concerned. So it must be in the form of order and it shall be communicated to the person concerned. Otherwise, the notings is a personal view of an officer for consideration by other officers. It can be overturned, it can be overruled, it can be modified. So, my lord, it cannot be given the exposure, my lord. My lord. So, to me. My lord, 2-3 citations are there, my lord. My lord, regarding that pension, but since my lord, pension rules are clear, my lord, those two conditions. Till remarriage, pension is admissible. And after the death, minor children. My lord, the writ petitioner has two daughters married off.
My lord,
Married off.
My lord, marriage has
Not minor.
That pension has not been defined, my lord. The family pension and pension. If my lord, immediately after remarriage it is stopped, then my lord, pension also will be stopped, my lord.
Minor daughters or minor sons will be entitled.
Three married. All of married. 3 children. No, second wife. Previous wife, my lord, I'm not even.
All are majors, my lord.
All are elder, my lord. 3 children, my lord. Yeah, married now.
So, my lord, that minor.
And my lord, then when notice was issued in this matter, 2019, my lord. Notice of motion was issued 2019, my lord. My lord, they have filed affidavit only on last week, my lord. And my lord, then in the time of notice of motion, my lord, That my lord, one of the, that.
Possibly due to COVID, my lord, the case has not been listed. My lord, I have been, my
And my
lord,
lord,
re-engaged, my lord, in 2019, I was not.
My lord.
My lord.
He's Mr. PJ Phukan, isn't it?
Yes, ma'am.
Standing counsel. Do you have any reply?
My lord, so far, my lord, that definition is concerned, my lord, that, yeah. The 143 is very much clear, my lord. The family includes that, my lord, wife in the case of a male officer, and my lord, 2 ways marriage for the purpose of admissibility, petitioner pensionary benefits to the spouse, a retired official shall mean marriage before or after my lord retirement. And my lord, regarding that pension will be admissible in the case of a widower. So my submission would be, my lord, in the case of widow, my lord, that it is one of still remarriage, my lord. She will get the pension till remarriage, my lord. And secondly, my lord, in spite of the widower, my lord, it is the death, my lord. And my lord, so far, my lord, the technicality, my lord, in the granting of my lord pension, family pension, my lord, then my lord, in that judgment, my lord, paragraph 7, my lord, whereby the constitutional bench has, my lord, make a very good observation, my lord, that judgment, my lord, 1989 for SCC 397. That I have cited that judgment, my lord. 1989 for SCC 397, my lord. That paragraph 7, my lord.
Yes. You said para 9.
Para 7, man.
7 also.
7. Well, 9 is very relevant in my case, but para 7 that regarding is a constitutional bench.
This is the definition of pension.
Right. So, technicality should not be a bar, my lord, in this regard.
You had submitted only one representation, isn't it?
One representation.
Which was rejected on the body of the
Yes,
representation. That was in which year?
2018, my lord.
18.
Yes.
Then you filed writ petition in 2019.
19. No, it is my submission.
My lord, I think, my lord, it will be better if the records are called for, my lord. Since, my lord, without record, my lord, these annexer A and C, very vital to the entire writ proceeding. Those
A and
footnote
C?
aspects, A and C.
What is A and C?
Page 14, my lord. The original document, and the type copy is page 12 and 13. This annexer 14 and annexer 7, annexer A, page 14, and annexer C, page 17. Type and translated copy at page 16. Footnote is there that it is as per Executive Council resolution. But annexer 4 is clear that there is no Executive Council resolution.
There is no?
Executive Council resolution on in 1982.
There's no. That though you admit, isn't it?
My lord.
That you admit, there's no resolution.
No resolution. So, my lord, records, original records should be required.
No, for what purpose should we call the records now?
My lord, regarding the change of name and regarding this rejection of petition, my lord. If it is at least, my lord, some order should be, my lord, communicated to the writ petitioner. There is no such order. And regarding this annexure A, regarding the name, replacement of first wife's name by the second wife, there is no such order, my lord. The order is of 1996, but after 10 years, there is a footnote that her name has been, my lord, replaced,
That you can verify if you want to.
my lord.
Mr. Sharma, do you have any marriage certificate
My lord, yes.
married to the late
There is
government
also a
servant?
certificate. It is a certificate from the Gaubura, my lord, the village head.
Gaubura?
Yes, my lord.
You have not annexed it.
No, I am not an.
What does it say?
I will say that to whom it may concern, certified that so and Devabala Das, so wife of so and so, the Thalasbury understood is district Kamru is a resident of this village.
Gaubura.
My lord, it's off the record, my lord. I have just talked with the treasurer. There are some other ladies, my lord. Two other ladies, my lord. My lord.
Two other
regarding-
ladies means?
Means, my lord, third, fourth, I don't know, my lord. So, my lord.
No, not in their affidavit, they have not put it anything,
Lord,
madam.
I'm not delving upon that aspect, my lord, but before, my lord, finalizing the pension, my lord, the succession certificate, no remarriage certificate, etc. would be required, my lord. If the second wife got remarried, then, my lord, pension won't be entitled to her. Then succession certificate and other things would be required. So, my lord, record, I think, if your lordship goes to the record.
Record, I don't think there's no requirement for the records, Mr. Pukan.
My lord.
The only thing is that how do we know that this lady is the second wife of the employee?
Prima facie, my
This
lord.
is one certificate you produce, but I don't know. Is there any other document?
But my lord, so far in the social marriage is concerned, my lord, no certificate. Because not registered marriage, my lord, you know, generally, my lord.
And this signature, my lord, it is some S. Chaudhary, my lord. He was a retired employee, my lord. LDA, not treasurer, my lord. Same person, my lord. He signed, my lord, in Annexure A and also in Annexure C. SC. S. Chaudhary.
But my lord, the representation was, my lord, submitted before the registrar, my lord. In the 2018, my lord.
The registrar has not put his signature, my lord, and treasurer also has not put his signature, my lord. And there is no marriage certificate, my lord, only that statement that in 1998 they have solemnized.
How to establish the marriage? This is the thing. Because you have not said the date also. You just said September 1998. What can you produce before the authority as proof of your marriage to this person?
My lord, that certificate is there, my lord, and one, my lord. Again, my lord, that village head, my lord, issued one, my lord, legal hair certificate, my lord. Legal hair certificate.
Legal hair certificate. Issued by whom?
Issued by the village head, my lord, Gaubura.
Your legal heir certificate, succession certificate cannot be issued by Gaubura. It cannot
But
be acceptable.
in Assam, my lord, that village head can issue, my lord, that certificate, my lord.
And a date of marriage has also been not reflected, my lord. Only the month, September 1998. No date, my lord.
What about succession certificate?
Succession regarding, my lord, succession certificate generally, my lord, that, my lord, movable and or here.
Immovable also.
Right.
Now, in respect of this heirship, I mean, in respect of this pension, can you not obtain a succession certificate that you will be entitled to
If my lord,
being
that
the wife?
deposit in bank or something, my lord.
Deposit what?
Deposit, if this is the deposit in bank, then succession certificate or nominee will be required, my lord. But so far, my lord, pensionary.
For the purpose of pension,
Pension, my lord, if in the pension paper, her name is incorporated, then my lord, definitely this will
no,
get.
that
But of course, my lord,
incorporation is not very clear, you
no,
see,
not very clear.
handwritten and all that.
Yes. But my lord, thing is that my lord, the grade 4 employee, my lord, wife of a grade 4 employee.
Maybe,
So,
but the thing is that if you are
and my lord,
entitled to
that-
pension,
yes, my lord, and my lord,
you should be the right person to receive it,
right.
that you were really legally married wife. It may so happen, we don't know.
Right. That is true, my lord. But my lord, that respondent authority also dealing with the matter, my lord, very casually, my lord. That their representation on submitted 2018, my lord. But they have kept the matter pending, my lord. Then again, my lord, the repetition also, my lord. And my lord, while issuing notice, my lord, that this honorable got observed that my lord, that pendency is not barred for my lord, dispose of or grant on the pension. So my lord, they may ask, they can ask the petitioner to personally present to make a hearing also, my lord. Or your lordship, from my side, my lord, lordship may direct to make a hearing, my lord, and keep the matter pending.
What can you produce before the authority? All these certificate, Gabura and whatnot.
Certificate,
What else can you produce?
this is a legal hair certificate. The village had certified that she is the married wife of deceased mother, that.
These documents have not been furnished by way of an affidavit. And I have filed an affidavit in opposition that has not been rebutted as yet, though it has been filed lately, my lord. So, my
Anyway,
lord,
since the matter relates to pension,
my lord,
person is an old lady, should not keep it pending.
my lord.
Will let me pass the order.
Only, in 2019, only 19/7/2019, the case has come up before this court. Then after long 5 years, on 16/8/2024, the matter has been listed. my lord. For long 5 years, my lord.
All right, you listen, I'm passing the order. Heard Mr. A.K. Sharma, learned counsel for the petitioner, and Mr. P.J. Pugan, learned standing counsel, Guwahati University, appearing for all the respondents.
My lord.
This is listed for what? Admission.
Admission.
Stop. Having regard to the nature of grievance projected by the petitioner, the writ petition is taken up for disposal at this stage. Next para. The case of the petitioner is that she is the second wife of, what is his name?
Nobin Chandra Das.
Late Nobin Chandra Das, who was a grade 4 employee working in the Guwahati University. Stop. Late Nobin Chandra Das retired from his service on 1/7/1995. And after his retirement, in the month of June 1996, his first wife expired. Please give the name. His first wife, that is Srimati Bimala Devi, expired. Stop. The petitioner and late Navin Chandra Das got married in September 1998. He was receiving pension that time?
Yes.
And all along, late Navin Chandra Das was receiving his pension. Well, how many children do you have?
3 children.
No. According to the petitioner, out of her wedlock with late Navin Chandra Das, they have 3 children. Son, daughter, how many?
3 daughters. 3 daughters.
3 children who are all daughters. Stop. Navin Chandra Das thereafter expired on 29/11/2017. And after his expiry, payment of pension was stopped by the university authorities. Of the petitioner on 27/4/2018 submitted an application to the registrar of the university for granting her family pension. But the same was rejected on the same day itself. By writing on the body of her application that second marriage after retirement will not be recognized. For the purpose of pension. Stop. Aggrieved with the same, the petitioner has filed the instant writ petition. Stop. Next para. Mr. A.K. Sharma, learned counsel, submits that during the lifetime of late Navin Chandra Das, the treasurer of Guwahati University had acknowledged the fact of late Navin Chandra Das being married to the petitioner. in the body of the communication dated 23/1996. Which contained the photograph of the petitioner and late Navin Chandra Das. Under his signature. Therefore, there is no dispute to the fact that the petitioner was married to late Navin Chandra Das as his second wife. And although their marriage took place after the retirement of late Navin Chandra Das, she would still be entitled to receive family pension, being the wife of late Navin Chandra Das. In terms of Rule 143, in terms of rule, you cancel that. In terms of note 2, number 2, note 2, below Rule 143, of the Assam Services, bracket, pension, close bracket, rules, 1969. Open bracket again, pension rules of 1969. Close bracket. Stop referring to the said provision, the learned counsel submits that marriage for the purpose of pensionary benefits to the spouse of a retired official shall mean marriage before or after retirement. Stop. He further submits that it is a settled position in law that no distinction should be drawn between marriage during service and marriage after retirement for the purpose of family pension. In view of the fact that pension is not a bounty. But it is a measure of socio-economic justice, which inheres, inheres economic security in the fall of life when physical and mental prowess, PROWESS, is ebbing, EBBING, corresponding to aging process, and therefore, one is required to fall back on savings. In support of his submission, the learned counsel relies upon the case of Srimati Bhagavanti versus Union of India, 1989, 4 SCC 397. And Ayatun Nessa versus State of Assam and others, 2004, supplementary GLT 366. Stop. The learned counsel thus submits that in view of the fact that the petitioner is entitled to family pension as per the relevant provisions of the pension rules of 1969. The respondent authorities may be directed to grant the petitioner family pension with effect from the date when pension was last given to her late husband, Nabin Chandra Das. Stop next para. Mr. P.J. Phukan, learned standing counsel for the university, on the other hand, submits that the footnote appearing in the communication dated 23/1996 made by the treasurer, Guwahati University, cannot be the basis for granting family pension to the petitioner. To stop, he submits that it is an established position in law that notings on the file, unless translated in the form of an order or notification and communicated to the person concerned, the same cannot be accepted. As a lawful document so as to entitle relief to the person who claims who makes a claim on the basis of such footnote. In support of his submission, the learned counsel has relied upon the case of Union of India and another versus Ashok Kumar Agarwal, 2013, 16 SCC 147, and Puranjit Singh versus Union Territory of Chandigarh and others. 1994 Supplementary 3 SCC 471. Next para, the learned counsel by referring to Rule 143 from rule you cancel, by referring to sub-rule within brackets small Roman 2, then within brackets small a of Rule 143 of the Rules of 1969, submits that pension will be admissible in the case of a widow slash widower, up to the date of her oblique his death or remarriage, whichever is earlier. Stop. He further refers to note 1 within bracket small Roman 4 below rule 143 of the rules of 1969, which provides that in the event of remarriage or death of the widow slash widower, the pension will be granted to the minor children through their natural guardian. Stop. In disputed cases, however, payment should be made through a legal guardian. Stop. By referring to the said provisions, the learned counsel submits that pension is admissible only up to the death
Miller, another provision may be added, Miller, regarding after inquiry to her right title to the pension, Miller.
Just a minute. Of the widow slash widower. Stop. Yes. What are you saying?
Rule 228 and 229. Page 308, Miller. 307 and 308.
228.
Rule 228, deceased pensioner. Page 307 and 308, Miller. That book. Down below.
307.
Page 307, rule 228.
Yes.
It should be within 1 year. It is all right, Miller. Now 229. After inquiry to her right and title of the claimant. Before payment, Miller, that inquiry, Miller.
He further submits that the entitlement of the deceased pensioner is also governed by Rule 228 and Rule 229
Miller.
of the Pension Rules 1969. Which provides that on the death of the pensioner, payment for any arrears actually due may be made to his heirs, HEIRS heirs, provided they apply for the same within a period of 1 year of the death of the pensioner. In the present case, no such application has been made.
Miller, application has been made within the time, Miller, but they're 229, Miller. Fourth line, Miller, fifth line. After such inquiry into the rights and title of the claimant, as may be deemed sufficient. Inquiry must be preceded before payment of the pension, Miller.
What did I say last line? That you cancel, huh?
There should be some papers, Miller, particularly regarding non-remarriage, Miller.
It relates to the areas of pension.
It is a year, my lord, since 2018, my lord. The husband expired in 2018, now 2024. Purely applicable, my lord. But the inquiry must proceed before the payment.
Referring to Rule 229 of the Rules of 1969, the Learned Counsel submits that in order to get any benefit of areas of pension of the deceased pensioner, the legal an inquiry has to be made into the rights and title of the claimant as may be deemed sufficient by the authority concerned. Stop. Therefore, in the absence of any such inquiry, the question of granting area pension or family pension to the petitioner would not arise. He therefore submits that the writ petition is without merit and the same should be dismissed. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Stop. From the projection made by the petitioner, the issue to be considered is whether the petitioner, as the second wife of the late employee, would be entitled to receive family pension. Stop. Note 2 below Rule 143 of the Pension Rules of 1969 provides that marriage for purpose of admissibility of pensionary benefits to the spouse of a retired official shall mean marriage before or after retirement. Stop. There is no dispute to the fact that the Pension Rules of 1969 is also applicable to the employees of the respondent Guwahati University. The petitioner, in his writ petition, has claimed that she is the second wife of late Nabin Chandra Das, which otherwise has not been specifically disputed by the respondent university. Stop. Only submission that has been advanced is that the petitioner cannot rely upon the notings made in the pension documents which shows that late Nabin Chandra Das had remarried. After his first wife expired. The notings made in the said document according to the respondent university cannot be the basis for claiming any right to receive family pension. To substantiate such stand, the Apex Court decision in Union of India and another versus Ashok Kumar Agarwal Supra and Puranjit Singh Supra has been relied upon. To stop, there is no argument to the fact that a noting by itself, a noting made in the file by itself unless put in the form of an order or a notification duly attested and signed by the authorized signatory cannot be considered as an authority to grant, cannot be considered, cannot be recognized. No, cannot be taken into cognizance as a decision on the subject. To stop. What is important to see in the instant controversy is with regard to the claim for family pension by the petitioner on the strength of being the second wife of the late employee. The same, as can be seen from the pension rules of 1969, is only admissible. It is, however, seen that the petitioner apart from the pension documents at annexure A of the writ petition containing the footnote supposedly signed by the treasurer, Guwahati University, has not produced any other documents to establish the fact that she is the legally wedded wife of late Navin Chandra Das. Under the circumstance, it would be difficult on the part of this court to give a direction to the respondent university to process the case of the petitioner for grant of family pension. However, at the same time, in view of the relevant rules in the rules of 1959 or 69. If the petitioner is indeed the late, wife of the late, is indeed the second wife of late Nabin Chandra Das, she cannot be deprived of the family pension. As may be entitled to a legally wedded wife of the retired employee. Stop. Under the circumstance, the petitioner shall under the circumstance, the respondent university would be entitled to make necessary verification to their satisfaction. Necessary verification in order for them to be satisfied that the petitioner is indeed the wife of late Nabin Chandra Das. Stop. The petitioner there shall therefore appear before the registrar, Guwahati University, bracket respondent number
2, my lord.
2, within
15 days.
a period of 15 days from today, along with all supporting documents in her power and possession, to show that she is the wife of late Nabin Chandra Das. You have your children also.
Yes.
Can take them also.
Married children.
3 children, my lord. Page 16 and 17.
The petitioner is also given liberty to produce her biological children born out of her wedlock with late Nabin Chandra Das, to establish the fact that she is the second wife of late Nabin Chandra Das. Stop. Upon her appearance, the respondent university what?
My lord will take a decision as whether she is entitled or not as per the pension rules. I think that will be suffice, my lord.
No, if she is the wife, she is entitled.
Yes,
That's
no,
what
my
I've
lord.
held.
Even after my lord, that my lord, this
Is satisfied that the petitioner is indeed the wife of late Nabin Chandra Das. The family pension, as may be entitled to her,
as per pension rules.
should be given to her without delay, which of course should be as per the provisions of the pension rules 1969.
As amended.
The responding university shall take their decision as expeditiously as possible, and not, and at any rate, not later than
2 months.
a period of 2 months
months.
from the date of appearance of the petitioner before the registrar of the university.
My lord, before the registrar, my lord, in presence of treasurer, my lord.
I think they are
My lord,
internal.
since my lord registered only.
You
my lord,
call everybody whom you have,
my lord.
Yes,
will
sir.
not say anything. I said registrar because he's the one who should be
But
there by name. I mean, he's the one who will be officially.
Actually, treasurer should have been included, my lord. Entire things would be done by.
You call the treasurer.
Administrative control of register.
You bring your people, whoever are there, bring them together, you all discuss and see what can be done.
Register along with treasurer, that would have been better, my lord. Anyway, my lord.
That's up to you. I'm leaving it up to you. With the above observation and direction, the writ petition stands disposed of. Under the facts and circumstance, the parties are directed to bear their own cost. Yes, you can do it.
Most obliged.
What number is ready?
Yeah, Twitter,
Yes.
Roshi. Here I'm appearing for response number 124, my lord. I pray some time for file my response, my lord.
How much time?
2 weeks time.
2 weeks. As paid for by the learned counsel, appearing for the respondent,
124, my lord.
numbers 1 to 4. Further 2 weeks' time is granted for filing counter affidavit.
Obliged.
Lordship, may fix the date. May fix the date.
Fixed date.
Yes.
After vacation, let the matter be listed again.
Obliged.
In that case, you make it 3 weeks. Not 2 weeks. Yes. 12. Yes.
Near pleasure of six, it is therefore compulsion of my lord. On land revision, the landed control of the response side submitted that they will take any instruction regarding the instruction of placing of DLC. My compulsion of my lord. On last revision.
Matter is not placed before a DLC, my lord. And SLC, he did not go there, my lord. No proposal was sent. I have gone through the petition, my lord. So what instruction they will come? The matter is, my lord, otherwise he was working temporarily 2014, they left it. Thereafter, he again approached the school for corporation appointment. Father died in 1996. Today, he is claiming corporation appointment, my lord.
Was it placed before the DLC?
Nothing.
Your case?
Till then, my lord. As per annexes 6 and 7, case.
No, you tell me yes or no.
Not.
Don't tell me read this page, read that page like that.
Not, my lord.
It was not placed before DLC.
Please.
Why? You submitted application or not?
Yes, my lord.
When did you submit your application? Where is your application?
My lord, can you see page 6, para 5. The petitioner begs to state that he having the requisite.
Paragraph. Document.
Document.
Your application.
6 and 7, my lord.
Huh?
Annex page 30,
Page 30.
33, my lord. 33, 35, my lord, kindly.
What is this? Submission of inquiry report. This is not your application. Your application for compassionate appointment, did you submit or not?
As far as after having submission, this inquiry report is given, my lord.
When did you submit?
Requisite time, my lord. Requisite time, my lord.
That's very vague. A repeated time means what?
My lord, he distributed after the death.
How did you file a writ petition without any documents?
My lord,
How do you make out your case without filing your application also?
my lord, as per NSS 7 and NSS 8. My case being placed before the DLC, my lord. For constitution of the case, my lord, NSS 6 and 7. And 8. 2 and 8.
You said an extra 8.
Hmm.
An extra 8.
NSS 8.
What is there in extra 8? It's not legible.
NSS 8, 35 and 36. NSS 7 is 33 and 34. A copy of caste sheet is 32, my lord. Kindly see, my lord, page 9, para 9. And also page 6, para 5. my lord.
You're taking me everywhere. I don't know. How should we understand your case? Why don't you articulate your submission from A to Z like that? I am so and so, son of so and so. My father expired on so and so. I submitted my application on so and so. It was received by them. Inquiry was done, but not placed before DLC. DLC met on so and so. My case should have been considered on that. Isn't it? That's how you should develop your argument. You're taking me to this. You said, see this page, see this paragraph, go to this annexure. You're taking me everywhere. I'm not able to understand your case.
My application, my lord, is not given.
Hmm?
I'll produce the application. My lord,
I think you should prepare your case properly. You come back again some other day. The learned counsel for the petitioner prays for some time to prepare the matter. List the matter again. When?
after vacation, my lord.
After vacation.
My
That's
lord,
grateful.
produce the application for commission of payment.
If you want, you produce. It's up to you.
English. Lordship, in this case, I am appearing for the Health and Family Welfare Department, Lordship.
Yes.
I have filed a affidavit in opposition yesterday only, Lordship.
Okay, none appears for the petitioner when the matter is called. However, Miss
Ms. D. Bora.
D. Bora, Learned Standing Counsel Health, appears and she submits that she has filed counter affidavit of the department yesterday. Stop. Since the affidavit in opposition is not on record, office to verify and connect the same to the record. List the matter again. When?
After vacation.
After the vacation. Petitioner would be at liberty to file rejoinder affidavit. In the meantime, so advised.
Obligations.
16. Your Lordship, I have received the instruction in this matter. On last occasion, Your Lordship granted us last opportunity to get the instructions. I have received it. I'll file an affidavit to that effect, Your Lordship.
You filed affidavit today.
No, I'll be filing it. I have received it day before yesterday.
What is the instruction?
Basically, instruction, if I have to place it before Your Lordship, just got one copy somehow.
Matter pertains to salary being
Not paid to the
given at the rate of what is given to Anganwadi helper.
No, Anganwadi workers.
She's saying that I'm getting the salary of only Anganwadi helper, although I'm working as Anganwadi worker.
That's right.
So what is your instruction?
That I placed, Your Lordship. I just had.
It's a very lengthy instruction. You summarize it.
Your Lordship, basically, if I had a copy, but somehow it is not here. But if I can actually just go through once.
Don't pass it on like that. You just tell me.
Your Lordship, basically, they were they are all overage as per the instruction. And they were not selected and engaged in a state post through any proper selection procedure as per any guideline. That is what the director.
Which post?
Anganwadi help worker. They were officiating.
Helper, so you don't have any dispute.
No. They helper. already
Helper, they were
helper.
appointed after selection.
Yes,
But for worker, there was no selection.
no. They were just told to.
So you take
officiate.
their service as Anganwadi worker, but you will pay them as helper.
That is basically, if I have to state it, your lordship, their proposal for approval to a selection and engagement of Anganwadi worker by way of upgradation promotion was received from the CDPO against 11 number of Anganwadi workers, including Anganwadi workers in question in the advertisement. Now, this particular each and every petitioner, they say that they had crossed the required age limit as specified as per the government notification. Whereas petitioner number 2, Srimati Gopa Vishwas, has been selected and engaged as Anganwadi worker. He is already selected and engaged. Petition number 2.
Worker.
He had
Madam, what is the instruction?
119 Patel Nagar, White.
Number 2.
37, 2024.
Lordship, when we were considered for promotion to the post of Anganwadi worker, we were not age barred at that time in 2014. Being eligible for promotion, we were allowed to officiate.
No,
as
he says that,
Anganwadi worker.
he says that petition number 2 is already promoted.
Petition number 2 promoted White order dated 37, 2024.
So
That instruction.
I'll bring everything.
for
on
petition number 2, it's infructuous, I think.
record.
Lordship will need that.
If what he says is correct, as per his instruction. So let him file his affidavit. You take your instructions.
I'll file an affidavit.
When can you file the affidavit?
Your lordship, 2 weeks time will be granted.
Okay, as prayed for Mr. D. Bora, learned State Council is granted 2 weeks time to file the instructions he has received
37, 2024.
by way of an affidavit. The learned counsel for the petitioner should also obtain up-to-date instructions from Heartline regarding their up-to-date status and the amount of salary they're getting. That is either as Anganwadi helper or Anganwadi worker. This is the matter again. When?
After Puja vacation, by the time I'll file everything. Immediately after Puja vacation, lordship may fix a date.
23rd.
Very good.
In that case, you make it 3 weeks.
Your lordship, the learned counsel for appellant Mr. PP Das is due to element cannot be present with your lordship. I think we passed over.
Compassionate appointment matter, his father died in 1999. After that, the wife applied, but later it was found that she is overage by 6 years and some months. So her application has been cancelled. Again, the son applied. Now, what happened in regard to his son, that he waited to pass his degree. After that, he applied. Ultimately, he should have applied within 2 years from him becoming major.
How long he waited?
He waited, I think, more than 10 years. So after that, he applied, and again, it was rejected for late submission of his application.
Is there any provision for condonation of age in compassionate appointment?
Ultimately, also this.
Is there any guidelines?
No, what I'm saying, Rosit.
No, I'm not talking about your case, this case. Generally,
That's what I'm talking about.
generally.
There is a judgment by the Supreme Court, Lordship, that Debabata Tiwari, State of West Bengal versus Debabata Tiwari case, Lordship. Basically, what the Supreme Court has held, when there is a delay, it's a delay. And the delay can be from the side of the petitioner and from the side of the government.
No, that is regarding delay. My question was regarding condonation of age, because son was too young and the mother is slightly old. So what to do in such circumstance? Either wait for him to become a major, or the wife is asked, the age of the wife is condoned.
Government law. If the government wants to relax the age, then, but that has to be guided by some.
That's what I'm asking you. Is there any such guidelines?
the affidavit, lordship, there is nothing in regard to that we have whether, because we have directly rejected the case. So if lottery also we can get some kind of the guideline, and this guideline has to be from the ministry, lordship. So.
You have it next week?
Yeah, next week, your
All
lordship.
right.
And all lordship after the vacation, lordship. Durga Puja
Next week,
vacation.
next week, what is time? Lordship, next week.
Okay, as prayed for by the petitioner, let's the matter again in the next week. You want a date? Otherwise, it may not come up.
Yes, also we can give it a try, lordship.
Sorry,
We can give it a try, lordship, on 23rd of September.
23rd.
23rd.
Must have.
Hello.
Yes.
So much.
May it please your lordship, my senior Mr. Arindas is not present today.
He's
Lordship,
appearing for?
I am appearing for ASTC.
Huh?
ASTC department. Responding.
RM Das is for whom?
ASTC.
ASTC.
Yes, your lordship.
He's the standing counsel.
Yes, your lordship.
What to do?
Next week, lordship.
Mr. RM Das Lanet, standing counsel ASTC, is said to have some personal difficulties to appear before the court today on prayer made on his behalf and not objected to by the other side. Please the matter again. Next week.
Next week.
What is next week? They say. Give a date. Yes.
Yes, your lordship.
Yes.
May I please your lordship. On the last occasion, lordship has directed the treasury officer at Hubli, my lord, to place the updated instruction. I have received the instructions, my lord. Lordship may kindly. Lordship may, first of all, my lordship may kindly be pleased to take up that bunch of papers, my lord, staple papers. There at the first page, my lord, lordship will find, my lord, this is the mandate given by the Office of the Accountant General. Now, my lord, since the petitioner's husband, my lord, he has expired. So therefore, my lord, the PPO has to be revalidated. Accordingly, it has been revalidated. And my lord, in the second page, lordship will kindly come to the second page of that bunch of paper. Lordship will see this is the mandate. After revalidation, lordship will kindly see, my lord, serial number 3 in the table. There is a short box, my lord, table box.
Yes.
There, lordship will find total recoveries 8,34,365. Lordship may kindly mark that, my lord. That is because the treasury officer has to act on the instructions of the authority concerned.
This is from whom?
This is, my lord, from the
AG.
Office of the Accountant General. AG.
From AG to Treasury Officer.
Treasury officer. The treasury officer is the executing authority. Treasury officer on his own jurisdiction cannot, my lord, determine. He has to only disburse.
So what is this figure?
My lord, that figure is, my lord, of 8,34,365. Lordship has seen it, my lord, that figure.
Yes.
And my lord, lordship will kindly see, my lord, the next page. This is, my lord, with regard to, my lord, order dated, my lord,
9/7?
yes, my lord. Order dated, my lord, 28/6/2024, passed in the instant writ case, writ petition, my lord. The third page.
No, where is that? This is a communication dated 9/7/2024.
Absolutely. So this is, their lordship will kindly see, my lord, the reference.
Yes.
After subject, it is reference. Your letter number so and so, Honorable Guwahati High Court judgment dated, it should be order, my lord, 28/6/2024 with respect to WPC 169 of 2023. That is the instant writ petition. Then, my lord, will kindly come to the next page. their lordship will find, my lord, the provisional pension that has been, my lord, paid. Provisional basic pension. I am reading it, my lord. Sir, with reference to the subject cited above, I have the honor to furnish here with the detailed royal statements of provisional pension and gratuity in respect of Srimati Jharna Padgiri. She is the petitioner out here, my lord. Wife of late Dulal Chandra Padgiri, ex-constable. So lordship will find that those provisional pensions have also been paid. Then, my lord, the next page, the statement of final pension in respect of Jharna Padgiri. That is the statement. There, lordship will kindly see, my lord, everything has been spelled out there, my lord.
This is not provisional?
Provisional. There, my lord, and in that particular page of statement, my lord, lordship will kindly see, my lord, net excess drawal down below. This is a calculation. 2,71,455. Lordship may kindly mark that, my lord.
Yes, excess withdrawal.
Excess.
Yes.
Then, my lord, the next page is
How it has become excess?
it has become excess, my lord, on account of overdrawal, my lord. That is to be, my lord, determined by the administrative department concerned, the employer, and, my lord, the office of the accountant general. It has been calculated.
Now, how it has become excess?
It has become excess, my lord, perhaps, my lord.
Overstay.
Overstay.
But for overstay, it was 4 lakh something.
4 lakh something, but that has been exhausted. So therefore, my lord, the next page. Next page, kindly see, my lord, the next page. This is a, my lord, communication by the writ petitioner to the treasury officer. Because a statement was made before this honorable court on the last occasion that the petitioner was, my lord, compelled by the treasury officer to sign, my lord, this application. But in fact, she has voluntarily, my lord, submitted this application to the treasury officer. Lord, may kindly see, I am reading it, my lord. Prayer for temporary hold of my final pension by FPPO number till disposal of WPC for waive of excess drawal. Now, since, my lord, here the issue raised by, my lord, the writ petitioner is with regard to, my lord, whether that excess drawal can be recovered or not. It is under, my lord, adjudication of this honorable court. So therefore, my lord, the petitioner herself has, my lord, requested the treasury officer to, my lord, hold up the, my lord, pension. With reference to the subject cited above, I have the honor to inform you that my pension has been finalized by the principal accountant general A&E by FPPO number so and so, in which there is a recovery of rupees 8,34,365. That lordship has seen just a moment ago, my lord. Lordship has marked it. Due to gratuity and other government dues overdrawal till date. As the aforesaid case pending before the Guwahati High Court by number so and so, for waive of all the above mentioned overdues during this period, I would like to request you to hold the proceeding of my final pension payment until the final judgment comes out. So it is her on her own volition that, my lord, the treasury officer has been requested to hold up, because that excess otherwise it will go, it will be exhausted. The least before this honorable court is now, my lord, whether that excess can be recovered or not. Now, lordship may kindly take up, my lord, that single page. There, my lord, the entire summary of, my lord, it has been made. My lord, this is the instruction I have received from the treasury officer. I am reading it, my lord. As per PPO number, I'm reading from the first paragraph, my lord. As per PPO number so and so, the principal accountant general Assam instructed the treasury officer Dhubri for dispersing lifetime area pension LTA at the rate of rupees so and so with effect from so and so to so and so. Then enhanced rate of family pension of rupees so and so with effect from so and so. Thereafter, normal rate of pension so and so with effect from so and so onwards, and accordingly, the total amount of pension with effect from 1/4/2020 to 31/8/2024 amounting to rupees 8,34,213, out of which an amount of rupees 6,01,751 has been paid as provisional pension, and the balance pension amount payable, that is, my lord, the differential figure, that is, my lord, 2,32,462. Then the second paragraph I am reading, my lord. the DCRG has been assessed at rupees 3,30,448 against the said pensioner, and out of which an amount of rupees 3,75,667 has already been drawn as provisional DCRG, and other government dues has been shown by Accountant General Assam amounting to rupees 4,58,698. And accordingly, after deducting all dues from the assessed DCRG, an amount of rupees 5,03,917 has to be recovered from area and future relief of the said pensioner. Provisional DCRG rupees so and so plus other government dues so and so minus DCRG due. It comes to, my lord, the amount of rupees 5,03,917. Now the last paragraph is important here, my lord. Therefore, the net excess dole payable amounting to rupees 2,71,455. That is excess dole of so and so minus the balance pension payable is equal to rupees 2,71,455 to be deposited to the government exchequer by the said pensioner before transferring the said PPO to the bank for disbursing of pension. The petitioner knows this calculation, and therefore, my lord, the petitioner has on her own volition requested the treasury officer to keep on hold the disbursement of pension, because this amount at the end of the day, lordship will be determining, my lord, whether this amount of rupees 2,71,455, that is the excess dole, can be recovered by the authorities or not. So this is how, my lord, the matter stands. So therefore, my
So
lord,
if this excess amount of drawal of 2 lakh something
my lord,
is remitted back,
my lord, then now there are two ways of, my lord, resolving the issue. Either, my lord, she will have to deposit, my lord, that amount before the treasury officer by way of, my lord, treasury chalan. Then, my lord, the remaining pension, it will be, my lord, disbursed to the, because nowadays, my lord, the pension is disbursed from the bank to her account, directly to her account. So the PPO that has been revalidated on account of death of the petitioner's husband, because it was earlier in the name of the petitioner's husband. On his death, it has to be revalidated. Now she steps into the shoes of the husband. Then, my lord, therefore, since on account of her husband, my lord, this amount is sought to be recovered as mandated, as directed by the office of the Accountant General. So therefore, my lord, she has asked the treasury officer to keep on hold. So therefore, either she will have to deposit that amount before the treasury officer, then the treasury officer, my lord, will send the PPO to the bank. From bank, it will be again, my lord, at normal rate, my lord, it will be disbursed. It has been disbursed to the petitioner, and prior to the petitioner, my lord, to her husband, and then now to the petitioner. Provisional DCRG, everything has been paid. It is not the case of the petitioner that nothing has been paid. Everything has been paid in accordance with law, my lord. What is due to her within the parameters of law, that has been paid. Save and except, my lord, this differential amount. And she knows it, my lord. Therefore, she has requested the treasury officer that please keep on hold, because this issue is sub judice before this honorable court. So this is how, my lord, the matter
so
stands.
what is the law regarding like, what do you call
Recovery, then,
recovery?
my lord, here lordship will find, my lord, that the husband of the petitioner, my lord, was working as, my lord, an unarmed branch constable, and he retired, my lord, on 28/2/2021.
So in the prayer portion, you see the figure which has arrived, they have arrived at
My lord,
is 4,58,698.
this will be, my lord, this is now, my lord, will be a wrong figure. In view of, my lord, the instruction, it will be less, my lord. After exhaustion, it comes down, my lord, to rupees, my lord, that amount, my lord, 2,71,455. The treasury officer has made a
That is
detailed calculation.
because there's some deduction done already.
Yes. Yes.
The figure otherwise is 4 lakhs.
The figure otherwise is polar, because therefore lordship will
Now,
find.
see, let us see, what is the number of months he has rendered in excess service is 11 months.
Yes, 11 months.
This 11 months salary is equal to 4 lakhs. This is
Yes.
how they've calculated.
Yes,
Now, meantime, what has happened is that the gratuity,
everything has.
pension, and
come
other
up.
benefits, all those things, provisional pension and all that, somehow has been disbursed.
Because my lord, that excess amount is to be calculated not only on the basis of the salary component, but with regard to other components.
Hmm.
So therefore, my lord, this figure has gone up. It, according to the petitioner, the figure is 4,58,000 and an odd amount, but according
Not
to the
just
accountant
according to
general,
me,
it
Your
is 8 lakhs. So they say more, she say less. 8 lakhs. Now, the treasury officer has made the calculation, which is before my lord, and Lordship has seen that the figure is 2,71,000 something.
Figures seems to be less, 2 lakhs.
Yes, this is the figure
Why it has become less is because
of the adjustments.
some amount has already been disbursed.
Yes, yes. It has been disbursed. So therefore, it is not the case of the
Some
petitioner.
amount has been disbursed and
Yes.
some amount also has been deducted also.
Yes, has been deducted because there are various components in my lord,
No, but the ultimate issue is regarding whether
benefits
deduction
to-
can be made or not.
yes.
If the court holds that no deduction can be made,
Then Lordship
then again, they will have to recalculate.
recalculate. They will have to recalculate. The administrative department concerned, that is the police authorities, will have to recalculate.
That is why I was asking you, what is the law regarding?
Now here, my lord, the only law will be
Recovery.
whether Rafiq Masih can be, my lord, brought in. Now, if
See,
yes, now if the pleadings on
Is
record,
can any person overstay for 1 day also
no,
on his own? Unless, of course, he makes a wrong declaration that my date of birth is so and so like that,
Yes,
and
yes, yes.
connivingly
yes,
he fails to disclose the correct picture.
therefore here.
Then he will be liable.
Yes, here is a case, my lord, where that overstay has arisen on account of non-disclosure of a wrong date of birth. That lordship will find at page 18 of the writ petition. For a moment, if my lord comes to page 18 of the writ petition, my lord, page 18, annexure 3. This is an order, my lord, passed by the employer. Passed by the employer of my lord, the deceased husband of the writ petitioner. Page 18, I am reading it, my lord. As per service sheet of CB so-and-so Dulal Patgiri of this DF, his date of birth is written as 13/2/1961. In pursuance of letter number so-and-so, the Deputy Inspector General of Police, Assam, Guwahati was asked to submit a copy of his admit card by this of his wireless transmission number so-and-so for correction of his date of birth. He submitted copy of his birth certificate of SSLC on 8/3/2021, and as per his admit card, he attained 21 years, 11 months, 13 days of age on 1/3/1982, and accordingly, his date of birth is ascertained as 18/3/1960. Then the second paragraph, as per government office letter number so-and-so, he had to go on superannuation with effect from 31/3/2020. But as per record, he received salary up to the month of February 2021, and thus overdrawn pay and allowances for 11 months. These have to be recovered from his pensionary benefits. So this is the source of, my lord, the action. This is the source of action of the respondent authorities. This is the basis.
He retired in February 2021.
Yes, my lord.
And this order was passed after his retirement.
After his retirement. Since, my lord, that anomaly was detected. Now here, my lord, if we apply Rafiq Masih, then, my lord, one thing has to be examined, my lord, whether, my lord, this was known to the authorities or it was, my lord, clandestinely withheld by the husband of the petitioner during his service tenure.
So where is the affidavit? No one has filed affidavit. When?
Well, my learned colleague, my lord, he is representing the employer. He will submit.
What is your stand?
Our stand is lordship, page 23, lordship. Para 6, relevant portion is 23 page. Lordship.
What do you say, madam? What do you say about this case?
Lordship, this matter fully falls under the context of Rafiq Mashi, Lordship, because in this in Rafiq Mashi matter, the Honorable Apex Court has been provided certain guidelines, conditions under which it is clearly mentioned that it is not.
You are ready to argue on Rafiq Messi?
Yes, Your Lordship.
Then we'll fix a date.
And Your Lordship, regarding the application, right now I came to know through the, as per my instruction, as per the instruction provided to me, the application was not submitted. So regarding that also, I'll have to obtain the instruction. The instruction provided to me was that the application was not submitted. And now I came
Okay.
to know that the application is submitted.
It somehow appears that application was submitted
Yes,
on the, with the intention that since they were going to recover it, what she wanted to say was, don't recover it, I file a case.
Absolutely, that is the tenor.
But-
That is the tenor of the
Huh.
application. And on the last occasion, my lord, my colleague friend, my lord, she made a statement before this report that treasury officer was putting pressure on her client to submit that application. However, she has refused to submit that application. Now that the instructions are placed before the honorable court, it is crystal clear that an application has been submitted. So my college friend may also take instructions on that. And on merits, my lord, lordship will be examining as to whether there is any element of fraud. If there is any element of fraud, then my lord, the
Okay,
legitimacy will
please,
not cover.
please write down, in terms of the last court's order dated 2/9/2024, Mr. R. Bor Pujari, learned Standing Counsel Finance Department, has obtained instructions. Stop, he submits that as per his instructions, the petitioner had submitted an application before the treasury officer to put on hold the process for final pension payment in view of the petitioner having filed the instant writ petition on 6/8/2024. To stop, he further submits that as per the calculation arrived at. Who has calculated this? Calculation is done by,
Done by the treasury officer.
calculation done by treasury officer.
Treasury officer, my lord, in terms of the calculation done by the employer, that lordship will find, my lord,
Treasury officer of which place? Dhubri. In terms of the calculation done by the employer, the outstanding dues, the excess drawal comes to rupees 2,71,455.00. The learned counsel submits that the same is the amount which is required to be deposited by the petitioner, or which can be deducted from the amount which she'll be entitled to. Stop. As for the permissibility or otherwise of the recovery for the excess service of 11 months rendered by the employee, comma, the same is between the employer and the petitioner. Next para, the learned counsel for the petitioner submits that she has no instructions as regards the application which was said to have been filed before the treasury officer Dhubri, and for which she prays for some time. She also submits that in view of the decision of the apex court, in what is the case? You have the citation,
State of Punjab. And
State of Punjab
others-
versus Rafiq Basi,
Yes, Your Lordship.
reported in The overstay in service being not the fault of the petitioner, not the fault of the employee, no recovery would be permissible. She submits that she is ready to argue with the matter on merits if a convenient date may be fixed for the purpose. Mr. A. Chakraborty, Learned State Council, submits that the state has already filed a counter affidavit. And submits that it was on account of the petitioner having failed to disclose his correct date of birth that the overstay has occasioned. Next para in view of above. Let the matter be listed. When do you want it?
Yeah, after vacation, after vacation.
Lordship, a short date, your lordship.
I think a short date is advisable.
Your lordship. And this
This way or that way.
extreme hardship, your lordship.
Huh?
So extreme hardship is being faced, so a short date.
Oh, you tell me which date you want.
18 September.
16, your lordship.
16 Sunday.
You don't want it in a hearing date?
18.
18 is Wednesday.
Yesterday.
18.
18.
7.
No, what? Ask her. She wants 18.
17.
17.
19 when I'm out of station.
24 minus.
24.
Mr. Mehdi, you're not out, you'll be out of station on 19.
19 I am yes, madam.
Where are you traveling?
Kohima.
You're not stationary in one place. Every time you're traveling from here to there to here,
24 is an ideal, madam.
and nobody can catch you also.
26, madam. 26 of
26.
What do you say, madam?
17, your lordship.
17.
Maybe.
Sorry.
You try, you try 17 then. She wants 17.
Yes.
Grant her that.
Respond 6 and 7.
This is the matter again on 17. Mr. S.K. Mehdi, Learned Counsel, appears for respondent number 6 and 7. And Miss, yeah. Anything else?
May a copy be provided?
Which copy?
Instruction that received by the respondent.
You WhatsApp her? Copy.
Lordship may be pleased to keep it as a part of the record. My lordship may-
The instruction received by Mr. Arbor Pujari is kept on record and marked as X for identification.
That's so obliging. That working machine citation is my lord 2015 for SCC 334.
Got it?
Lordship, here, your lordship, petitioner's father, petitioner is claiming for compassionate appeal. His father,
Compassionate appeal.
his father, your lordship, was working as sub-inspector, your lordship. In the, under superintendent of police Dubri, Assam, your lordship, had voluntary retirement, retired on 36/2009, your lordship. Thereafter, your lordship.
He was working as sub-inspector.
Sub-inspector of police in district executive force under superintendent of police Dubri, Assam, your lordship.
District, what do you call?
Dubri.
No, district technical force, you said.
District executive force.
Executive force, okay.
He retired,
DF.
he voluntarily, due to, he was, while performing his duty, your lordship, he sustained injury and he was handicapped, your lordship.
When?
And regarding this certificate was also issued and he voluntarily retired on medical ground on 36/2009, your lordship.
36/2009.
Thereafter, your lordship,
on medical grounds.
On medical grounds, your lordship. Thereafter, the father of the petitioner, your lordship, submitted an application for his praying for a job, your lordship, on compassionate ground on 37/2009, your lordship.
Son of the petitioner.
Son of the petitioner, your lordship.
37/2009.
Yes, no, your lordship. Father of the petitioner submitted application for his son, that is the petitioner, for petitioner, your lordship.
Who retired on?
Father, your lordship.
Father retired.
And after his retirement on 37/2009, father submitted an application
For the petitioner.
For the petitioner, your lordship. Then, your lordship,
he applied for the post of ASI, Your Lordship. But the respondent number, Deputy Inspector General of Police, Your Lordship, submitted a letter informing that ASI post is not for compassionate appointment, Your Lordship. That thereafter, the father of the petitioner again submitted an application, Your Lordship, and by letter dated 17/9/2009, Your Lordship, it was the petitioner was informed that his case will be placed before the DLC, Your Lordship. But there was no action, Your Lordship. Then petitioner's father, Your Lordship, again submitted application on 2/9/2010 and 8/6/2011, Your Lordship. Thereafter also, Your Lordship, there was no response from the respondent side, Your Lordship. Then, Your Lordship, kindly peruse page 30, Your Lordship. Page 30 on 23rd February 2012, Your Lordship, the mother of the petitioner was informed that his petitioner's case, not Your Lordship, 16 March 2012, page 31. Here. May I read, Your Lordship?
Just a minute.
Page 31, Your Lordship, Annexure 12.
Yes, 31.
With reference, it was informed to her mother, to his mother, Your Lordship. Mrs. Nilima Khatun is the mother of the petitioner, Your Lordship. With reference to the letter on the subject cited above, I'm directed to inform that the case of your son, Rahul Alam, that is the petitioner, Your Lordship, was not recommended for appointment on compassionate ground by the district level committee, Dhubri, as intimated by the Superintendent of Police, Dhubri, and Additional Director General of Police, Assam. Here, Your Lordship, in this letter, Your Lordship, there was no reason, and also there was no mention on the DLC meeting on which it was rejected, Your Lordship. Then subsequently, Your Lordship, petitioner, that letter also not been informed, communicated to the petitioner, Your Lordship.
Then how did you get this letter then?
On his visit, thereafter, Your Lordship, on his visit to the office of Superintendent of Police, Dhubri, Your Lordship, in the year 2018 also, Your Lordship, he submitted an application, page 40, Your Lordship, kindly read. Page 40, Your Lordship.
Yes.
There also he petitioner submitted an application for appointment on compassionate ground. There was no action, Your Lordship. And again on 18/11/2022, again he submitted another application, Your Lordship.
Now, if you go on medical retirement,
Yes, Your Lordship. There is a scheme, Your Lordship, on the Office Memorandum 1/6/2015. I annexed in the writ petition, Your
what
Lordship.
am I going to ask you?
Yes, Your
You know what I'm going to ask you?
Lordship. Sorry.
Why are you firing away?
Sorry, Your Lordship.
I wanted to ask you, if you go on medical retirement,
Yes,
do you get any pension?
yes, Your Lordship. He's
How
getting
much pension? Full pension?
that instruction. He's getting pension, Your Lordship, as per my instruction, but I'm
He's
not-
getting pension.
Yes, Your Lordship.
He's not that, he just has been discharged. He's getting pension, isn't it?
Yes, Your Lordship.
So now the second question is what you want to say regarding compassionate appointment. Does it cover, a person who has gone on medical retirement,
Yes, Your Lordship.
the family entitled to be considered for compassionate appointment?
Yes, Your Lordship. Office Memorandum dated 1/5/1.
What does it say? What does it say?
It says that dependent of family members, Your Lordship, has been explained.
Dependent on family members?
Yes, may I read, Your Lordship? Dependent of family member means a person who was wholly dependent on government servant at the time of his death in harness or retirement on medical grounds.
Or retirement medical? Okay,
Medical.
okay,
Yes,
fine.
Your Lordship, subsequent to filing of this writ petition, Your
So
Lordship,
retirement happened on 2009,
2009, Your Lordship.
10, 11, 12. Communication. Initially, you filed application for ASI appointment. They say that compassionate appointment cannot be given in that rank of ASI.
Yes, Your Lordship.
So DLC ultimately considered your case. And they say that it was
As
rejected.
per their letter, Your Lordship, but they have filed affidavit in opposition, Your Lordship.
What does it say?
In affidavit in opposition in paragraph number 7, Your Lordship, may I read, Your Lordship? With regard to the statement made in paragraph 5 of the writ petition, the opponent begged to state that that the petitioner memo number so and so was received at Dubri on 19/9/2009, but it could not be placed before the DLC as the meeting was held on 16/9/2009. So it was informed to IGP Assam Police Headquarters, Assam Guwahati, that the matter was put up in the next DLC on 14/6/2010 and put up accordingly. Then paragraph number 9, Your Lordship. With regard to the statement made in paragraph 7 of the writ petition, the opponent begged to state that DLC Dubri not considered his petition as per my notes. It was not valid on all aspects and not fit for appointment. There is no mention of the DLC meeting, Your Lordship. And on what ground it has been not considered, that also not been mentioned. That's why, Your Lordship, this honorable court on 11/3/2000.
What is the date of the DLC meeting,
DLC meeting.
according to which they say that it was considered?
14/6/2010.
14/6/2010.
10.
Before which district?
Dubri. Your Lordship.
Dhubri. And according to the court's order, you are saying something?
And court order 11/3/2024. Your Lordship. Respondent was directed to file detailed affidavit, including office memorandum that was in operation for appointment on compassionate ground when the father of the petitioner took voluntary retirement, as well as the DLC notes dated 14/6/2010.
Has it come? DLC minutes?
After that, they have filed another affidavit in additional affidavit, Your Lordship.
Is the DLC minutes available?
No, Your Lordship. They have not, they have annexed only the office memorandum stating that all other earlier office memorandum has been superseded and office memorandum 16/2015 is applicable, Your Lordship. And in that office memorandum, there is a clause, Your Lordship, under which the voluntary retirement can be considered, Your Lordship.
Where's that page number?
Page number 52, Your Lordship, of their additional affidavit in opposition, Your Lordship.
52.
Yes, Your Lordship.
Annexure?
Annexure A.
Where's the 11? Okay.
At the bottom, Your Lordship, 2.
Yes. Retirement. This is what you have read.
Yes, Your
This
Lordship.
is what you have
And
read.
in the in earlier affidavit in opposition, they have admitted that an application in 18/11/2022 is pending, Your Lordship. So at this stage, my simple prayer, Your Lordship, his application may be placed in the next DLC meeting and considered as per law, Your Lordship.
Where is that? Admission.
In their affidavit in opposition, paragraph number 12, Your Lordship. Earlier affidavit in opposition, which they filed on 7th October. Your Lordship.
Mr. Bora, you're there?
Yes, Your Lordship. Let him complete, then I'll actually say.
Page 44. Paragraph 12. The application is still pending, it seems. Can you consider it in the next DLC?
Your Lordship, first and foremost, let us understand the concept of compassionate appointment here.
Back to that
Question
West
is,
Bengal.
Can a person claim compassionate appointment when he is alive? That is the
No,
question.
no, see, your own office memorandum says that
That I'll come to that also. I'll
No.
come to that.
father who is retired is not claiming appointment. It is his son.
No, Your Lordship, I have to start right from beginning. If Your Lordship peruses through my immediate latest affidavit which I have filed, I have annexed the application filed by the father, the deceased father. He, after getting the VRS, now there is a difference between VRS and normal retirement on medical grounds. And that is what the scheme says, retirement on medical grounds.
Nobody's talking about VRS.
Very well, Your Lordship. Then I may take Your Lordship to page number 33 first of the scheme. If I may just read out. On what basis a person is entitled to be appointed on compassionate ground? What would be the ground?
You come to
Either he
page-
has to die in harness.
No, you come to page 54, it is there. Your affidavit. Office
No,
memorandum,
before that, Your Lordship.
1st June
just need to-
2015.
just One line, Your Lordship, just one line. Just one line of page number 33 of the scheme itself. First paragraph itself.
Yes.
In the middle, after careful revision of the matter, the governor of Assam, as a lordship,
Yes, yes.
is now pleased to supersede all the earlier office notifications along with corrigendum and orders issued in the context of the said OMs and lay down the following principles and procedure to be followed while dealing with the issue of compassionate appointment to the dependent of a government servant who die in harness or retire prematurely on being permanently incapacitated as declared by a certificate issued by state level standing medical board and receives invalid pension under the provisions of Rule 82 of the Assam Services Pension Rules 1969. Has that happened here in this particular case? They stand on a two different footing. Petitioner's father voluntarily retired, not on this particular ground that he was declared permanently incapacitated by a certificate issued by state level medical board. That has not been attached to this writ petition. That has never happened. Only then only he will be entitled to get compassionate appointment. After getting VRS, he was never a member of the force. And that incapacitation was not due to the act of service when he was in service.
He had taken VRS.
He has taken VRS in 2009 itself. That
Where is that? Where's the?
He himself has stated, Your Lordship. And it is here.
Oh, he says that retirement on medical grounds.
No. He has annexed it, Your Lordship. I'll just take Your Lordship.
Yes, Your Lord, on order page 21, kindly.
Page 21.
In my writ petition, Your Lord. And before that, I have annexed the feasibility certificate also, Your Lordship. The page annexure to page 19 and 20, Your Lordship. There is a photograph which shows that father of the petitioner lost his left leg, Your Lordship.
He himself prayed for voluntary retirement from service due to his high diabetes and loss of leg.
With one leg, how will you serve?
That is what, Your Lordship. That
He
is not
is
due
the
to incidents of service.
sub-inspector.
And in the order itself is written that he will
Ill health,
retirement
Your
on
Lordship. That is
medical
not
ground,
to
Your Lordship.
incidents of service. Had it been incidents of service, had he lost his leg due to incidents of service, then yes, he could have been covered under that particular clause number 2. Retire prematurely on being permanently incapacitated as declared by a certificate issued by a state level medical board, which has not been had.
Okay, you all argue on a separate date.
Yes, Lord.
And
It is not that simple as like you were saying.
but
Application pending and all that.
On several occasions, Your Lordship, this honorable court had asked them to produce the minutes of the DLC meeting.
You also produce the minutes?
On what
Your
basis
Lordship,
my case has been?
DLC, he was never placed. The necessity would never arise if he went
But
on
in the,
VRS.
in the affidavit of position that they have stated that.
No, but your affidavit says so otherwise, no?
I'm not recommended, Your Lordship. In paragraph 7, Your Lordship.
No, who is respondent number 4?
Respondent number 4, I'm representing respondent number 4. I have
No.
filed the affidavit.
The name of the authority. That's what I'm asking.
Superintendent of Police Dhubri.
SP
Dhubri.
Police. Your Lordship. SP Dhubri.
He says that paragraph 12, the application of 2022 will be placed before the next, since there's no DLC now, we'll place it before the next DLC.
No, it says that he submitted application on 18/11/2022 for placing before the DLC. But as no DLC is held since that time, the petitioner has not yet been put up. But the question is of putting up, Your Lordship, would arise later on. This issue has to be looked into. There was no report. He has not annexed any report from the state level standing medical board.
Okay, right. The case of the petitioner is that he retired, his father retired from service on medical grounds. And therefore, the petition is entitled to be considered for appointment on compassionate basis. since the same is covered by the office memorandum dated 1/6/2015, issued by the Government of Assam in the Department of Personnel, Personnel bracket B. Open bracket, Annexure A to the affidavit in opposition filed by the respondent number 4. Close bracket, full stop. Mr. D. Bora, isn't it?
Yes, Your Lordship.
Learned State Council, on the other hand, submits that both these OMs are of the same date.
1/6/2015.
Yes, the one which I was reading also is 1/6/2015.
Yes, Your Lordship.
Yes, Your
That's
Lordship.
Same.
OM.
That I have annexed in the writ petition itself, Your Lordship.
Which one?
Page 33, Annexure 14.
Page
Annexure 14 is what you have annexed.
Yes, Your Lordship.
We have also annexed in affidavit, in additional affidavit.
By referring to the office memorandum dated 1/6/2015, issued by the Government of Assam in the Department of Personnel, from a Personnel B department, not department, Personnel B. Annexed to the writ petition as Annexure 14, he submits that benefit of compassionate appointment can be given only if the government servant retires prematurely on being permanently incapacitated as declared by a certificate issued by the state level standing medical board. Stop. However, in respect of the petitioner, he was released on voluntary retirement as prayed by him due to his high diabetes and losing his left leg. Stop. Since the pleadings are complete, let the matter be listed for admission hearing. On
Any hearing date, Your Lordship?
Any hearing date, Your Lordship? Third of October, Your Lordship.
yes, on 3rd of October.
Oblige, Your Lordship.
Oblige.
May I please, Your Lordship. My lord, in this case, my lord, there are altogether 14 petitioners, my lord, praying for minimum pay scale and regularization of the services under the APDCL department, my lord. But out of the 14, my lord, 11 has been granted the benefit of enhanced pay, my lord. And there are 3 petitioners, my lord, who has not been granted that benefit, my lord.
During pendency of the petition, my lord, 11 of them already received the enhanced pay, my lord. However, on the last occasion, my lord, the Honorable Court had directed to obtain instruction with regard to 3 petitioners, more specifically petitioner number 4, 8, and 13. Today I have received the instructions, my lord.
What is that?
My lord, there is a meeting dated 6/8/24, my lord. Perhaps the next page, my lord. In agenda 3, my lord, and the last part of the agenda 3, my lord. Discussing about the present writ petition, my lord, the members of the committee analyze and discuss in detail the report submitted by the field officers. It has been found that out of the 15 number of petitioners, 12 of them had received the enhanced pay as per the office order so and so dated so and so. Therefore, the committee recommended that more details may be sought regarding the enhancement of engagement of 3 petitioners as well as the payment vouchers and other supporting documents, my lord. With regard to this, my lord, yesterday, my lord, the APDCL, my lord, CGM has issued another letter to the General Manager Revenue Silchar, my lord, requesting to furnish the payment records of the engagement, my lord. Payment records. To payment records, my lord, of them, my lord, those 13 employees, 3 employees, my lord.
4, 8 and 13.
Yes, my lord. Because, my lord, to consider the case, my lord, at least they have to, my lord, 10 years of continuous service, my lord.
You cannot produce it or what yourself?
Since they have not produced at the time of, my lord, document verification, my lord, we have sought for the payment records that will suffice the cost, my lord.
So
Perhaps.
some more time required?
Yes, my lord. After 4 weeks, my lord, perhaps if they are considered, my lord, nothing remains in the reputation also.
Who has sought from information from whom? Please come again.
My lord.
Who has sought information from whom?
Yes, the Chief General Manager, HRA APDCL, my lord, has sought information from the General Manager, Silchar Revenue Zone, my lord.
Chief General Manager has sought information from?
From the General Manager, Silchar Revenue Zone, my lord, APDCL CAR, Kasar.
Silchar Revenue Zone.
Yes, my lord. APDCL, Kasar, CAR. My lord, there is in the letter only, my lord. Letter dated 12/9/24.
Okay. Please write down in terms of the last court's order dated 2/9/2024. Your good name?
B. Das, my lord.
Mr. B. Das, Learned Standing Counsel, APDCL submits that the instructions which he has received is that since there are no materials to show the continuity of the service of the petitioner numbers 4, 8, and 13 for at least a span of 10 years, in order to entitle them the enhanced remuneration of rupees 17,000 per month. The Chief General Manager, bracket HRA, APDCL, has sought the details of payment records in respect of the said petitioners from the General Manager, Silchar Revenue Zone, APDCL. Invite his letter dated 12/9/2024. To stop pending such information, the Learned Counsel submits that the matter may be adjourned. The said prayer is not objected to by the Learned Counsel for the petitioner. In view of above, let the matter be listed again after the puja vacation.
Yes, ma'am.
My lord, a fixed date may be provided.
In
On
that case, my
so and
lord.
so. A month's time will go, 1 month time at least.
Yes, my lord. যদি ওনারা কনসিডার হয়ে যায় না কিছু না থাকবে টেলিফোনে হলো নাম্বারটা নিচে 24 my lord, I'm
On
obliged.
24th
I'm obliged, my lord.
October.
May it please your lordships. My lord, this petitioner is going to file an additional affidavit in the next week, lordships. The matter may be fixed thereafter, lordships.
Additional affidavit.
20,
Why do you want to file additional affidavit?
lordship, certain information I am going to place before His Honorable Court, lordships. And also, lordships, from the APDCL side also, no affidavit has been filed as on today.
You have taken the permission of this court to file additional affidavit? Okay, you have already taken.
Yes. And we have also received the instructions today itself, my lord.
Learned Counsel for the petitioner submits that he may be given further 2 weeks' time. When?
Lordships, on 30th September, matter may be fixed.
To further 2 weeks' time to file additional affidavit to bring on record certain developments in the matter. Developments.
Lordships.
Stop the Learned Standing Counsel, Mr.
B. Das, my lord.
B. Das, Standing Counsel APDCL, Mr. B. Das, submits that he has also received instructions and he will be able to file the counter affidavit within 2 weeks. In view of above, and as prayed for, let the matter be listed again on 30th of September.
Lordships.
Our place.
Yes, Mr. Kaushik.
My lord. My lord, here on the last day, the government sought time to place the instruction that they were moving, that they are trying to act upon the prayer which has been prayed in the writ petition. My lord. My lord, an order has been passed on 10/9.
My lord, I have received the instructions. My lord. Let me kindly have a look at it. My lord,
Under consideration.
Lordship. Well, the kindly similar serial number, I'm reading one. I'm directed to inform you that the prime claim of petitioners regarding their promotion to the rank of Inspector UB, along with their 49th batch SIUB, is already under the zone of consideration. The following steps have already been taken. Number one, inter-se seniority of petitioners have already been refixed along with the 49th batch. That order is there, my lord, and we have marked as Annexure A. Then, my lord, services of the petitioners are confirmed with effect from 1/12/2014, along with the same batch of 49th wide AP headquarter wide memo number dated so and so 10/9/2024. This order is there, my lord. Annexure B is there, my lord. That is one of their main prayer. And my lord, now the promotion is also, my lord, under consideration. The serial number 3. Up-to-date service particular departmental proceeding, court case pending, contemplated if any, as well as up-to-date ACR APRs in respect of the petitioners have already been sought for from the concerned authority of the district organization wide AP headquarter letter wide memo number so and so dated 28 August 2024. Then, my lord, next page, the AP headquarter wide letter number so and so dated 9th of September 2024 directed the ICs of the concerned cell of AP headquarter to furnish reference, if any, regarding the pendency of court case, human rights, SPAC related cases in respect of each of the petitioners. Not these informations they have sought for consideration of their cases for promotion. The last para that it is pertinent to mention that on receipt of the reports, the necessary follow-up action will be taken pertaining to promotion to the rank of Inspector UB in respect of each of the petitioner. So, if Lordship may kindly takes up the writ petition, the prayer made in the writ petition, Lord.
Page 31 and page 31.
Lord, Lordship may kindly take up the first writ petition, Lord, the other item, WPC number 3835 of 2023.
How many petitioners are there?
Lord, 2 petitions, 10 petitioners are there. 2 writ petitions, 10 petitioners.
In all.
Both the petitioners are same.
Same, Lord.
In the first writ petition, my challenge was with regard to fixation of my seniority with the 49 batch. However, not giving me any retrospective benefit with regard to pay fixation. In my challenge in that was seniority has been fixed. Now, what the facts of the case is like this, 2007 an advertisement was issued. We participated in that advertisement. A select list was published. It was put to challenge before this honorable court, my lord. In that writ petition, the government comes and say that yes, the select list was wrongly been done and they will redo the select list. So 11 years thereafter, they redo the select list and I was appointed in 2018. Then, my lord, we were given the batch which was appointed along with me. They were sent for promotion. I challenged that in a writ petition, my lord. In the meantime, my lord, they fixed my seniority with that batch which was appointed along with me, but without giving me the pay benefits. That is the second writ petition which is pending before your lordship at 3835. That is. And thereafter, after the seniority was fixed with that 49 batch, I was sent for pre-promotion training, my lord. I passed the pre-promotion training, but in the promotion order, my names were not there. I put a challenge to that writ petition, put a challenge to that promotion order in WPC 5525, that is item number 24. Now, the instruction which my learned friend is placing 10/9/2024, that order, my lord, if your lordship kindly takes up that order, my lord. Annexer B,
Annexure B
Annexure B.
in the bunch, my lord,
in the bunch.
that I have placed.
If lordship, Annexer B, second page, my lord, you can receive. The paragraph starts from, my lord, it is evident.
Yes.
My lord. It is evident from the above that these 10 SIUBs of police are required to be promoted to the rank of inspector of so-and-so along with 49 batches. However, according to Rule 39 of the so-and-so, directly recruited the sub-inspector can only be promoted to the rank of inspector after completing 6 years of service post confirmation. In this case, the aggrieved inspectors, sub-inspectors were appointed in the year 2018 and confirmed in the rank with retrospective effect from 21, right? Order dated so-and-so. While a literal interpretation of the rule would render them ineligible, the matter needs to be examined in the light and spirit of the direction of the Honorable High Court, as it is important to note that the Honorable Guwahati High Court has already ordered their appointment and seniority to be considered along with 49 batches. This by implication means the confirmation should also be aligned with the batch. Failure to do so would undermine the intent of the Honorable Guwahati High Court's order and unfairly deprive these 10 sub-inspectors of UB of their due. Therefore, my lord, to kindly note this. Therefore, in order to ensure justice for the aggrieved sub-inspectors, it is hereby ordered that the previous confirmation order dated so-and-so are superseded and their confirmation is recorded as having occurred along with 49 batches with retrospective effect on 1/12/2014. My lord, it clear, my lord, what I can understand, my lord, this is a step to facilitate my promotion along with the 49 days. But the promotion orders have not been issued. So lordship will keep this
Promotion,
petition for pending for.
That is what, my lord, I have said in para 3 of my instruction, para 3 and 4. They said that the promotion is underway and they have, for the purpose of promotion, ACR, ADR, the departmental proceeding, court case pending, contemplated, if any, those informations they have asked for. If lordship kindly comes to Annexure C and Annexure D, my lord. These are the
Petition.
of the
this petitioner.
of the bunch, my lord, of this bunch, my lord, instruction
bunch, okay.
of this bunch, my lord. Annexure C and Annexure D, my lord. On 28th of August 2024, from the headquarters, the service particulars of the confirmed SIs have been sought. These are the 10 petitioners, my lord. And Annexure D, lordship will find the status of the pendency of any court case, human rights case, as a state police accountability case, criminal case, etc., or pending or contemplated against the following sub-inspectors. These are the required information, my lord. After receipt of these informations, in fact, the promotion process is on, my lord. After receipt of this information, then they will go to the next step, my lord.
And
Para-
for
para-
my instruction,
para
my lord,
3 and
pursuant to
para
that
4.
letter of 28, the petitioner has already submitted these documents, my lord. Lordship. Your lordship will keep this matter pending for some time, my lord. Let them
When?
apprise.
But my humble submission is, my lord, since the promotion process they have initiated, their seniority has been fixed with the 49 batch, my lord, and now these informations have come. Lord, keeping this matter pending at this stage will serve no purpose, my lord. The promotion process, lordship may say, my lord, within a period of
Some steps have been taken.
Some steps, your lordship will kindly
in fact,
see
the
my
promotion
prayer
process-
in
promotion
page
process is
32
underway, my lord.
is giving me promotion with effect from 3/11/2021, from the date when I have been deprived along with the other batch.
So what is there to press now?
Because they have
Can we
taken
not
a
close it?
step, giving me a confirmation with effect from 2014 so that they can facilitate my promotion. But
Understood.
the promotion has not been yet given. So if your lordship pending, because if they
the-
don't do it, my lord, I'll have to come back again, my
The
lord.
process
If
needs
your lord,
some time, lordship may kindly observe that within a period of 3 months, they will complete it everything. Because they said that informations, whatever is required, they have already given. And my lord, paragraph, this instruction, lordship.
Is that the only relief you're claiming for?
my lord, my
That you should be given the seniority and the pay benefit?
see in the writ petition WPC number 3835, that writ petition pertains to a challenge that with regard to the fixation of seniority of 49, but not giving the retrospective effect of notional benefits. That writ petition, they have
Notional,
not,
notional.
notional benefits. They have not answered anything about that writ petition.
But this communication now says that you'll be given.
No, it doesn't say so, Mala. This communication simply says that my confirmation of that was given on 1/12/2021 has been superseded, and now it has been given an effect from 1/12/2014.
But it is, Malad, obviously, Malad, when the confirmation has been taken, counted from 2014, the ancillary thing or consequent thing that has to be counted, Malad.
If my lord kindly takes the WBC 5525/2023, my lord.
Yes, yeah, yes.
My lord. Item 24. There are two prayers in this writ petition, my lord. Page 31. One, possibly, my lord, is not required now. Roman 2 of page 32, my lord. That would be the Roman 2.
2.
Roman 2. Page 32. First prayer is setting aside the promotion of all the private respondents. And Roman 2, my lord. Direction respondent to promote the petitioner to the rank of so and so with all promotional benefits, including fixation of seniority in the cadre of Inspector of Police, with effect from 3/11/2021. This, there is no certainty in this communication, this order of 10/9.
In fact, the prayer number 2 has been taken care of by the first paragraph of my instruction, my lord. Kindly see, my lord, I'm reading, my lord. If lordship with due permission, my lord. They said that the prime claim of the petitioners regarding their promotion to the rank of Inspector UB along with their 49th batch SIUB is already under zone of consideration. Along with their 49th batch, because the 49th batch people, they have been given promotion already in the year 2021, and it is under consideration. That is what we have said in the first paragraph of our instruction there. And that is why, my lord,
Under a zone of consideration and giving
Yes,
a effect
yeah,
to the promotion is a different.
all the other persons are junior to them, my lord. Though they were promoted on 12/9/2023. They were promoted on 12/9/2023.
This is my third round of litigation.
Junior, my lord.
So we keep it pending then.
My lord, we keep it.
Otherwise, my lord, the first petition, this has become infructuous, my lord, because they challenged the 12/9/2023. They said that all the persons are junior without giving us promotion. You have promoted junior persons.
Itu infraction হৈ গৈছে এটো আগতে কৰি দিছে এটো আহা নাই
And my lord, the second prayer is also here. Lordship will see.
মানে এটো ক্লোজ হৈ গৈছে
কোনটো
এটো রিপিটিশন এক নম্বর কোনটো WBC
5525
5525 টো নতুন
এইটো তোমাৰ ক্লোজ PX 35 ক্লোজ
এটো আছে এটো ফিক্সেশন টো
থাকে তো বলে lordship, if lordship is taking up 5525 of 23.
Yes.
There the first prayer, my learned friend is also agreeing. He is also agreeable that 12/9/2023 he has challenged because the junior persons were promoted in that order. Now, as because he has been confirmed with the 49th batch, my lord, and their promotion has been already under consideration. So, my lord, he may not have any grievance against the order dated 12/9/2023. All these persons are junior, my lord. That has already been taken care of.
So prayer 2 and prayer 3 remains.
Yes, it
prayer 2, my lord. Prayer 2, they said that appropriate direction to the respondent authorities to promote the petitioner to the rank of Inspector with all promotional benefits, including fixation of seniority in the cadre with effect from 3/11/2021 along with 49th batch. My respectful submission is, my lord, our instruction placed before your lordship says that along with the 49th batch,
with retrospective effect from 1/12/2014.
Yes.
Why the dates are not tallying?
No.
No, that's a confirmation. My confirmation in service. I was appointed in 2018, but later as a probationer.
Hmm.
It was confirmed in 2021. Now to facilitate my promotion, I need to have a 6 years of service.
Yes.
After and to facilitate that, my confirmation has been given a retrospective effect from 2014. So by 2024, I am 10 years. So now they have no difficulty in giving a promotion
So
with effect from 2021.
if that is the case, why are you insisting on the matter to be pending then?
No,
They're
because
taking steps?
no, the lordships, the prayer 2 is for giving me promotion from 3 to 11/2021. This, your lordship,
Along with 49 batch.
along with 49 batch.
Yes.
And this order of 10/9, which is placed as Annexure B, my lord, it is only with regard to giving me confirmation,
Understood.
not promotion.
No.
So things will
over-
have to,
over
will
and
have to go
above.
step by step, isn't it?
Step by step.
Over and above that, my lord,
And the second step is not yet completed. It
No.
is under the zone of consideration.
my
Mr.
instruction is,
Dinath,
Lordship,
we'll record your instructions and post it again sometime.
my instruction first paragraph, it is clear, my lord. Kindly see, my lord, the first paragraph.
There's no dispute, my lord. It
No.
is under the zone of consideration.
Their promotion to the rank of inspector along with their 49 batch, because that is his prayer, my lord. That you consider my promotion along with my 49 batch mates. It is under consider along with their 49 batch. SI is already under consideration, my lord.
First paragraph.
Yes, first paragraph of the letter, the instruction which I have placed, my lord.
Well, I don't know, my lord, why this pendency is bothering the government, my lord. Because
The
they need
first
to just-
paragraph,
Yes, my lord.
interstate seniority of so and so has been refixed.
No, my lord, that is number one. Before that, my lord,
You said the first paragraph.
with reference to the above, the para starts with
No, it
reference
says
to
the prime claim. That is a claim of the petitioner.
No.
It's not that they're doing it.
my lord, let me, kindly, my lord. I am directed to inform you that the prime claim of the petitioners regarding their promotion to the rank of inspector UB along with their 49 batch UB is already under zone of consideration. It is along with their 49 batch, it is under consideration. That is what they want to say.
Hmm.
And that is what they are praying.
So let it remain.
Lordship.
Mr. Dinath, Learned Counsel. Learned Counsel appearing for the state has produced the instructions received by him, wherein it is seen that as per the respondent authorities, steps have been taken for promoting the petitioners, correct?
Yes.
My lord.
In the rank of Inspector of Police within bracket UB,
UB.
along with the 49 batch of SI within bracket UB. Mr. B. Kaushik, Learned Counsel for the petitioners, submit that since the process has not been completed, the same may be awaited considering the submissions made. Matter be posted again after the puja vacation.
Lordship.
Well,
Let it be the middle part of November, my lord. They need 2 months, possibly 2 months time, my lord.
List again on
They will by that time may complete this successfully. In that case.
November, when? 13th, 20th?
20th, my lord.
Let it be in the first week, my lord. Let them apprise, my lord. If by this time it is done, my lord, my reputation will become.
6th of November, 2024.
My lord. Obliged.
My lord,
Instruction received by Mr. Dinath is kept on record and marked as X for identification.
my lord, can this be the third week, my lord? Let them complete it, my lord. Vacations are there.
When?
2 months time, they may require, my lord. Let it be on 18th, my lord. Let them come on that day dispose of it. Let it be on
Mr.
18th.
Nath is very, he's good in his insisting, is it?
My friend wants my reputation to be disposed without
Okay.
giving a consideration. Now
No. Without,
Okay.
it is under consideration, my lord. It is
13th.
13th, my lord.
Obliged.
Lordship. Obliged.
Yes,
May it please your lordship. Under this case related to the regularization pay of the casual workers and all. Casual workers, workers, employees and others.
how many petitioners?
There
14,
are
15.
15. And
Where are you working?
we are working for the last 10 years
Where?
in various division of the forest
Forest.
department.
Okay.
Mainly they are under BTC, my lord. BTC area.
BTC.
Yes. So, my lord, no, BTC council is required, my lord, here. No one is.
Have you seen the last court's order?
Yes, I have seen, my lord. I was absent that day and they have stated many things. But why don't they file the affidavit then?
No, it says also that you are covered by that Upendas.
Yes, I'm covered by the Upenda's case.
So can it not be disposed of in that line?
Yes, it can be disposed of.
Paragraph 20, 22 or 20, 22. You'll get the minimum scale.
Okay, my lord. And I have annexed also one of the judgment, my lord, passed by learned single judge also. That is in page, my lord. The last annexure. That is annexure 23, page 118.
180,
118.
180,
118.
118.
In 118. And the relevant page is 122.
One, two, two.
122 page, my lord.
No, it's okay. We'll dispose it off.
Yes, my lord.
Your good name?
Lordship, if I may, Lordship, here I'm appearing for the finance department.
Ah.
Lordship, here, even to get the minimum of the pay scale, Lordship, the names of the petitioners have to be forwarded to the finance department for approval, Lordship, if they are entitled to it.
No, we're not saying that give them directly. Of course,
Yes.
that scrutinized will be there.
Yes.
As per the
Yes, that is the verification will be there.
Yes.
verification and scrutiny will have to take place.
If they are entitled, Lordship, then they'll.
Then,
Yes.
Obviously.
That verification may be done.
Are you thinking that we're going to direct them to be given that pay tomorrow?
Yes, Lordship, yes.
It can't be
But
like that. What's your good name?
A Bhattacharya.
Heard Mr. A. Bhattacharya, learned counsel for the petitioners, and Mr. A. Chaliha, learned standing counsel, finance
And
department,
for respondent number 2, Lordship.
appearing for respondent number 2. Stop. Having regard to the nature of the case projected by the petitioners, the same is taken up for disposal at this stage with the consent of the learned counsels appearing today. Next para. 15 petitioners have joined hands to file the instant writ petition with a prayer that since they have been serving as fixed pay workers, how many years?
More than 10 years, my lord.
For more than 10 years
Yes.
under the Forest and Environment and Forest Department, Government of Assam, on fixed pay basis, they are entitled to be considered for regularization of their service.
Lordship, if I may, Lordship, in Upenda's regularization wasn't the issue. Lordship, they were asking for minimum of the pay scale. Here, my learned friend, he has made a prayer for regularization, Lordship. That will be different from the minimum of the pay scale.
So we're not giving that regularization. We'll
Yes,
say that
Lordship.
we'll consider them as Upendas.
Minimum of the pay scale was not in the prayer portion, Lordship. That is why I just wanted to highlight. The prayer portion, he has not made a prayer for minimum of the pay scale. He has asked for regularization.
regularize the service of the petitioner as fixed pay worker.
Regularization.
Regularization of fixed pay. That is the word used by the, in their office also, forest department also.
Lordship, that was that point of time, Lordship. Now.
Regular workers are not fixed pay.
Regular workers.
Fixed pays are irregular. Or the
Ye-
casual
yes,
workers
yes.
are given fixed pay or
Yes.
contract employees. Next para, it may be stated herein that a division bench of this court in state of Assam and others versus Sri Upendas and 836 others in writ appeal number 45 of 2014. While disposing of the said appeal on 8/6/2017. Had interfered with the judgment and order of the learned single judge, by which direction was given to the writ petitioners. Direction was given to the state respondents, the state authorities, to regularize the service of the writ petitioners. To stop the said decision, having regard to the claim made in the writ petition, is found to be squarely applicable. And therefore, no direction for regularizing the service of the petitioners can be given with the law laid down in, no, with the law laid down in council that can be given. Stop. However, the writ appellate court at paragraph number 22 of the said judgment had directed the respondent, had directed the state authorities to grant the employees concerned the minimum pay scale after due verification of their service particulars. Stop therefore, while rejecting the claim of the petitioners for regularization of their services, the respondents are hereby directed to consider the case of the petitioners in terms of paragraph 22 of Upendas and 836 others supra for grant of minimum pay scale by verifying their respective service particulars. You will file a representation?
Yes.
What is to be done?
Yes, I filed representation.
No, now we will file. Will you file?
Okay, I will file within 3 weeks.
The petitioners shall file their representation before the respondent number
Before the respondent number 6 and 7, it will be.
Respondent number 3.
PCCF, respondent number 3, by enclosing all the service details before the respondent number 3 within a period of 3 weeks from today. And the respondent number 3, upon receipt of the same, shall process the same. And ultimately, if the petitions are found entitled to receive the minimum scale of pay after the verification of their respective service particulars, the same should be given to them without further delay. The entire exercise be carried out within a period of 3 months.
3 months.
Prior orders, we have had 4 months.
Where 4 months?
Lordship, the order that has been annexed in this writ petition itself. 3 months also, Lordship.
3 months from the date of receipt of the representation to be filed by the petitioner.
Obliged.
With the above observation and direction, the writ petition stands disposed of.
No, please, Lordship. Lordship, it's a pension matter.
Yes.
Lordship, petitioner is a old lady. Lordship. Lordship, we don't have instructions in this matter as of yet. Sometime may be given.
We are short of time now. See,
Anyway, we don't have any instructions.
you don't have any instructions.
Yes.
You have not filed affidavit.
No.
Or this affidavit is filed by the petitioner.
No.
What is the issue here?
Pensions of the Panchayat employees.
Huh?
Pension of the Panchayat employees. Those who had the service of less than 20 years, whether they are entitled for pension or not. Determination of this kind of rule.
It come after 2 weeks, my lord, we will have to.
As prayed for by the learned counsels for the respondents, further 2 weeks' time is granted for filing, for obtaining instructions and for filing counter affidavit.
Lordship, kindly fix short date next week.
2 weeks is a short date. 44. 44, admission. Yes,
I'm appearing for respondent number 4, 5, and 6. We need 4 weeks time to file our affidavit. Lordship.
none appears for the petitioner when the matter is called. However, the learned, what's his name? What's your name?
PP Das, Lordship.
PP.
PP Das.
However,
Appointed
Ms. PP Das, learned counsel appearing for respondent number
4, 5, and 6.
4, 5, and 6 is present and prays for 4 weeks' time. How much time?
4 weeks.
4 weeks' time to obtain instructions to file counter affidavit. Mr. D. Shutia,
1, 3, 3, and 6.
DC. TC. Mr. TC Chutia, learned counsel appears for respondent numbers
1, 2, 3, and 1 of 6.
1, 2, 3, and 1, 2, 3, and 6. And also prays for 4 weeks' time to obtain instructions to file counter affidavit. Prayers allowed. List the matter again after the puja vacations.
Lordship.